Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack's at Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Prosecuted, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends. Hello and welcome. Today is Friday, February 27th, 2026. And thank you so much for coming to spend part of your day with me. Happy Friday. Happy Friday. Well, there's a Kelsey Fitzsimmons hearing today. It's called a trial readiness conference, and it's in front of the new judge, Judge Karp. And the good news is that people in the know have reached out to me to tell me that Judge Karp is the nicest judge, the nicest judge. So that's one good thing she's got going for her today, and we've got going for us today. Bad news is there's no live Zoom feed for this hearing, and so I'm going to need your help, cupcakes. All of a sudden, after we did the live stream yesterday, all the mainstream media started picking it up. I don't know if there's going to be a pool camera in there today, because I don't know if anybody made a motion timely. Law Girls Not Attorneys is going to be in the courtroom. They have provided me with their live link. They are apparently allowed to stream it, so we will go to that feed. But if anybody knows of any local mainstream media, such as NBC 10, WCVB, Boston 25, that is going to be live streaming this hearing, let me know. So, if there is, yeah, but I need somebody who's going to be live streaming, not live tweeting, live streaming. I am aware of all of the new filings in the O'Keefe versus Reed case. We will be talking about that at 6 o'clock. Hi, Cheech. Fox 25. Oh, wait, hold on. WBZ there, I'm sure. WC, I mean, are you sure? Are you there like you're sure? Like they're in the courtroom? Like who's there in the courtroom, and is it going to be on their website? I know, but I'm not going to live stream Justice Serves live stream, because I don't know if they're live streaming it or taping it for later. I wouldn't do that because I don't want to take their views away. Let them get the views on that. Christina Rex was not, they're not sure. I need to know if there's Channel 10. And I've got NBC 10 Boston up on YouTube. Kelsey has also filed a last-minute motion to be heard today. She wants her bail conditions changed. She wants to be able to go live in her own house. And she wants to be able to drive. And so we're going to see what has happened, what is going to happen with that. It is not Fox 25. It is Boston 25. Okay, so Christina Rex is there. That's fantastic. But I need to know who's live streaming. So all of this other information that I have to sift through to find it. Boston 10, I saw had a live feed. Okay, that's what I'm talking about. That's what I'm talking about. Let us see. They make it difficult when they don't allow The Zoom. That's the thing. That's the thing. I have the papers on the new motion regarding the bail conditions, which we will go over after, assuming we can find a live stream that is not, that has a good camera that we can hear and everything else. So there's that. Mm-hmm. Mm-hmm. Well, let's see. So are they going to stream it live on their website, Boston 10? Hearing today. I mean, they've got a feed up. I just don't know if they're going to live stream it. This is Boston 10. Probably doesn't help me. Probably doesn't help me. How did Justin return her laptop? Did he break in again? Oh yeah, the story's everywhere now. Now the story's everywhere. Now that Justin's been caught on camera with his three cronies. Hold on one second. I'll listen to this in my ear. Oh, please. Here's my email scrolling along on the bottom of the screen. Fanbase@mlittlelaw.com. If and only if you have a link to an actual news organization who's going to be live streaming it, please send me the link. Otherwise, we will go to Law Girls Not Attorneys and use their feed because they are filming from inside the courtroom today. And she sent me the link and said that I could use it. Now, with regard to and so now Boston 10 is live on YouTube or they're live on their website. Okay. I'm going to say this one more time. Justice TV are there filming. I am not going to swipe their live stream. I don't do that. And to the person who sent me an email today that my mods sent to me that said, can I restream your live stream on my YouTube channel? It's a very small channel. No, it's frowned upon in the YouTube community. Boston 10 is live on YouTube now, but they're not talking about this hearing unless it's going to come up. And so I don't do that. I don't swipe other people's live streams and stream their live streams unless I have explicit permission to do so. So my email is at the bottom. If you have an actual link to an actual stream, let me know. And then at 6 p.m., we're going to pivot over to all the new filings. The O'Keefes are desperate. They are desperate to get Karen's phones. The O'Keefes have filed for a restraining order, and they want Judge Doolin, I think it's Judge Doolin, to refuse to allow Karen Reed's phones to be released back to Karen Reed. Okay. It's scrolling along the bottom. So if you want to email it to me, email it to me. And I see nothing yet. But I do have everything else for Karen Reed, and we're going to do that later. And we're here for it. They really, really, really don't want anybody to watch the Kelsey Fitzsimmons hearings, especially after what happened yesterday. And so it's a shame, but Scott and I have a bet. I'll let you know if somebody wins the bet. Yeah, they said they want others to share the stream. Who are we talking about? Justice served? Hold on. Are they going to be live streaming it though? Sometimes sometimes they do it. And then they, sometimes they tape it and then they use it later. But if they are the pool camera, that's a different story. So I'll put them up on my thing here too. Okay. Cheech is here, says Melanie. They haven't let them in the courtroom yet. And once they do, I will have it for you. You're the best, Cheech. Are you there? Are you there? Are you in the courtroom? Are you in the courthouse? Are you boots on the ground as always? As always, boots on the ground. Okay, you're the greatest. You win. Dawn is the winner. Winner, winner, chicken dinner. She's got the live feed for Boston 10. And so that's what we're going to watch. Thank you, Dawn. I love you with all of my heart. We're so collaborative here, aren't we? So collaborative. It was the whole thing. I had to email the clerk, and then I had to ask the clerk for the link for the Zoom. And then the clerk said, yeah, no, we don't have Zoom. And so you have to come in person. Thank you, Cheech, for all your help. You guys are the greatest. I'm just going to put this on mute for right now. And of course, we can boost it if we need to. Now I'll take down my email because I get tons of troll emails every day. And that is that. Okay. Nice courtroom. This is in Lawrence today. Interesting. Nah, just in it for the money won't be there because this is not a civil hearing. This is a criminal hearing. Thank you, Dawn. You're the greatest. Baby, you're the greatest. I don't know if they're going to hear the motion on the bail conditions today. This is a new judge. This is Judge Karp. From what I hear, he's really great. Oh, there she is. Thanks, Dawn. You're the greatest. You guys are on it. You guys can do anything. I mean, look what you did for Edric Faust. Look what you did for Edric Faust. You're helping spreading the word about his case, about the modern day lynching that we watched in Athens, Georgia. And we ain't got no quit in that case, and we are going to be back. They're trying to get Brian Steele hired to handle the appeal, but it's going to take over $100K. And so we are trying to help raise money for that. Now, with regard to the new motion that was filed, I don't even know if it was filed yesterday or today in the Kelsey Fitzsimmons case. And we have the papers. We'll look at them after the hearing. Kelsey Fitzsimmons' lawyers, Tim Bradl and Martha Coakley, are asking the judge to modify what they described as medieval bail release conditions. Medieval. That have her under 24/7 house arrest and are unable to seek custody of her infant son. Yes. Remember, Kelsey is hamstrung from being able to go back into family and probate and family court to try and get custody of her son based on the rulings of Judge McCarthy Neyman. If you're not familiar with this case, there's extensive show notes underneath this video. And the courtroom is still empty, so we're waiting. And as you know, last fall, Superior Court Judge Kathleen McCarthy Neyman allowed Fitzsimmons to be released with strict conditions, which included a GPS bracelet, alcohol testing through the SCRAM device, and house arrest with the ability to leave only for medical appointments and meetings with her lawyers. McCarthy Neyman also barred Fitzsimmons from seeing her infant son after her fiancé, just in it for the money, Aylaian, said she had threatened the baby's life, which we know is ridiculous. When Fitzsimmons' lawyers said she couldn't comply with the alcohol testing, we remember that, which required her to blow into a tube because of her gunshot injuries, collapsed lung, chest tube insertion, etc. McCarthy Neyman threw her back in jail. Remember? That was on September 11th. It went all the way up to the highest judge in Massachusetts, the SJC, and they also upheld Judge McCarthy Neyman's ruling. But then what had happened was Bradl filed another motion saying there's been a change in circumstances. Kelsey's now well enough to be able to blow into the SCRAM device. Please let her out. And the judge did. This morning, Tim Bradl and Martha Coakley have filed a motion saying that the conditions that were imposed by Judge McCarthy Neyman, they also made a motion to recuse her, which was quickly resolved by the Chief Justice in Essex because it alleged a lot of shenanigans on the judge's part and her ex parte communications with the probation officer for Kelsey Fitzsimmons and the accusations against Bradl, et cetera. We went over that motion as well. There's a whole playlist linked below this video. I can't even imagine how many videos I have so far in this case. So in the motion that was filed this morning, Tim Bradl and Martha Coakley said that the conditions imposed by McCarthy Neyman were generated under highly questionable circumstances. As you know, as we just discussed, they had filed a previous motion accusing the judge of misconduct and seeking her recusal from the case. The motion was denied and deemed moot because the chief judge moved McCarthy Neyman off the case. And it was deemed moot. Fitzsimmons is now seeking, through this new motion that we will read after the hearing, she's seeking to modify the conditions of her bail, allowing her to live at her home, drive herself around from 7 a.m. to 11 p.m., and to lift the alcohol restrictions, which the lawyers say are completely unwarranted. Remember, this alleged crime had nothing to do with alcohol. It was based on some hearsay, double hearsay, ex parte, ipsy dixit ruling. And papers that the judge shouldn't have considered in this proceeding that were filed in the family and probate court by just in it for the money Aylaian. There's our friend Tim Bradl, the silver fox, walking into the courtroom, shaking hands, pressing the flesh. While out on bail, Kelsey has been living with her mother and stepfather. I'm gonna put the
all right.
Thanks, Diane. Here we go. I'm gonna try this unboosted. Let me know if you can hear it.
Court in session, be seated, quiet in the court.
Calling number 22 on the list, Commonwealth vs. Kelsey Fitzsimmons. Calling number 2577, January 11. Counsel, please identify themselves.
Good afternoon, Your Honor. James Gubitose on behalf of the Commonwealth. Hello, Your Honor. Timothy Bradl on behalf of Kelsey Fitzsimmons.
Good afternoon, Your Honor. Martha Coakley on behalf of Kelsey Fitzsimmons as well. All right, good afternoon.
Judge, can I ask as a preliminary matter if Ms. Kelsey might be permitted to join us? Ms. Fitzsimmons might be permitted to join us at counsel table.
No, I only do that for a change of plea.
Dawn, I love you with all my heart, but this is a hearing from 3 months ago that you just sent me. So that's the link that you sent me. This is not today's hearing. I got a little too excited. Oh my God, are you trolling me? All right, hold on. Law Girls didn't start yet. And I don't think Justice Served has started yet either. So that's an old hearing. False alarm. I was like, why is she staying back there? That's hilarious. They're not in the courtroom yet. It's 2 p.m. I was wondering why she was in the box too. Okay, epic fail. Back to 1, everyone. That's hilarious. All right, Dawn, you got credit, but Thanks for trying anyway. Nah, we're waiting. Justice Served is going to put it up. And apparently you guys are telling me that everyone could use it. So if he's the pool camera, that's good. Shout out to Lindy Kenny Bodden and Michael Bryant for doing the Lord's work. Michael drives there for all of these hearings. And from what I hear, getting to Essex is, or Salem is like not easy, right? Oh, well. That's funny. I hope somebody was restreaming me. Nothing to see here, folks. Nothing to see here. All right, I've got it up. So when they come on, now I can keep talking. Now I can keep talking until they actually go live. All right, cool. Cool. So here's how they want to modify her bail conditions. They want her to be able to live at home. I thought her home was sold, so I don't know if she's got a new home. They want her to be able to drive herself around from 7 a.m. to 11 p.m. and to lift the alcohol restrictions, which they say that was just practice. That was just a dry run. Assistant Essex District Attorney James Gubitose told the judge in August that she had struggled with aggression and alcohol abuse dating back to high school, citing testimony that Fitzsimmons' longtime friend gave to North Andover police. This isn't new, he said. Oh, please. And so, as we know, the hearing is supposed to be coming up at 2 p.m. And I hear Judge Karp is great. So we will make our own determination on that. Fun fact, Judge Karp, the judge that's going to be sitting on Kelsey's case today, is the same judge who is currently on trial in the John Kerry case. Remember the John Kerry case? That's not being televised either. John Kerry is on trial currently in front of Judge Karp. It's been going on for a few weeks now for the 1986 murder of Claire Gravel. And as far as I know, trial's still ongoing. It's on the calendar for today. Nobody's reporting on it, this John Kerry case trial. Jess Machado says there's 50 people there in support of Kelsey. And she's live tweeting from the courtroom. So we got that going for us. And we wait. Oh, please. Oh, please. Well, Lisa says, I can't believe Justin hasn't been charged with all that he did. So sick of the fix. Well, I mean, now that it's public and everyone's reporting on it, it would be really interesting if they decided not to charge him with anything, him and his 3 buddies who clearly broke into Kelsey's home. I mean, it's on video, for Christ's sake. And I don't know. The public outcry is a lot right now. It's a lot. But I mean, a couple good things have happened for Kelsey. In the meantime, Judge McCarthy Neyman's been taken off her case. It's been reassigned to Judge Karp. And we'll see what happens. If anything, to just in it for the money. How can they not? I don't know. It's insane. We've seen many witnesses get intimidated since witness intimidation charges were brought against Aiden Carney, many people, and none of them have been prosecuted. They seem to like to selectively prosecute their laws in Massachusetts, and it's in your face too. It's literally in your face. What say you? Cheech says, so glad the video came out because now everyone is covering and not just saying Kelsey did XYZ. Well, it's about time the mainstream media picked up, even though the breaking news that we saw last night when we were after my show, after I reported it, was factually incorrect on a lot of issues. Connie So Fancy sent a scathing detail email to news director at NBC 10 about the inaccurate breaking news report we watched yesterday. I will email it to you. Thank you very much. Connie, figure 10, NBC 10 YouTube live stream for Kelsey. I just had it up. However, hearing, so I mean, we'll see if they pick it up. But in the meantime, I've got other ones up. And Suze, you know my email. If you have a link to an actual hearing that's happening today, please send it to me. Because the one I had up, I see this was from 15 minutes ago, was a 3-month-old hearing. Thanks to Just Irish for appreciating me. I appreciate you even more. You can believe it. They're not allowed in the courtroom yet. So as soon as they are, we'll put it up. We're trying to find out, Amber. I've got 2 other feeds up that people that are in the courtroom that can film from in the courtroom. So it is not on Zoom. They have not opened a public Zoom feed. Thanks for tuning in from Canada. But as soon as it starts, I'm going to put it up for you. We'll see it. Gigi says, they cannot wait for the video you post where just in it gets picked up by the ice cream truck. I already engraved his cuffs. A pretty shade of red. Oh, you're sweet. That's so sweet of you. Thank you, Master Shenanigans, for gifting 5 memberships. You're awesome. You're awesome. And Gigi gifted 10 memberships. Thank you to Gigi and to Master Shenanigans, to the 15 new members. Welcome. Welcome, welcome. Oh, is that what you think? Yeah, let's all put our patience pants on today. Cupcakes. Thanks, Melissa. Law girls. Hold on. All right. Thank you. This is Law Girls, not attorneys. They're live in court. Send me the link to be able to use it. So we'll check it out. See if we're going to be able to hear what's happening. This is a different courtroom. This is. And once again, there is Tim Bradl, our silver fox on the left in a trench coat. Martha Coakley to his right. She's the former U.S. attorney from Massachusetts who has joined the defense team for Kelsey Fitzsimmons. In the show notes below this video, you will find the link for Kelsey's fund. If you care to donate and you have the ability to donate, that would be greatly appreciated. It seems that Justice Serve TV is using Law Girls feed right now on their channel. So this is what we have. We get what we get and we don't get upset. Once again, I'm going to put my email scrolling across the bottom. So if you find someone from mainstream media who's got a camera in there, you can email it to me. The link, the actual link of the actual hearing that's actually happening today. Please. Today. That was really funny. Thanks, Law Girls. Justice for Kelsey. And Manja says, I rewatched the last few episodes back. Is the video we watched with Jason and his buddies? Justin. It was yesterday's stream that we played it. On yesterday's stream, it's Justin and 3 other guys breaking into Kelsey's house, disabling the security system, ripping it out of the wall, disabling the alarm, ripping the modem out of the wall, and stealing things from Kelsey's home such as her passport, her laptop, cash, and then taking her laptop back to his home where he proceeded to maybe change the beneficiary on her pension, get a refund on the honeymoon money and divert that money to his own personal account, access her medical records, and other such things like that. And that was yesterday's stream, and everyone here was outraged. Thank you, Elaine, for your very generous 100 by Venmo. She says, I'm running behind. I needed this as the day has been a mess over here so far. Thank you, Elaine. You're so kind and generous to the channel. Yes. We got it. NBC 10 has it. Shout out to our girl, another Melanie sent this to me. Boston 10 streaming live. We got it. That's what they do, though. The thing is, they put it up like so late. Like they put it up sometimes after it already started. But we're there.
Hey, what's up? How are you?
Tim Bradl, press in the flesh.
Yeah, sure.
Thank you, Melanie. There's a lot of Melanies on this channel. It was a very popular name back in, the 60s. Thank you, Nate Taylor. What's the FD Facebook page? I don't do Facebook, really. I mean, I have it at like an old account, but I never use it. Every time I go on Facebook, it just makes me mad. Thank you for your super chat.
Yes. Yeah.
Wow, look at all the support in the courtroom. There's Kelsey's dad. Look at all the boots on the ground. Woohoo! Shout out, boots on the ground. A lot of support for Kelsey. Listen, court, if you're not going to run a public Zoom, you're going to have a lot more people showing up. Remember that one judge where they did a phone hearing and he was yelling at Tim Bradl because there were so many people there? And he was yelling at Tim Bradl because he didn't show up in person. However, they were notified by the clerk that it was only going to be a phone conference because they have like the old party lines there. Hi, Boston Liz. Boston Lisa, I'm really sorry. She says, can't Kelsey go to Andover police and press charges like anyone would do if their home was burglarized? Well, her attorneys sent all of the proof to the district attorney personally, which is a better route to go if you can, and they just ignored it. Thank you, Boston Lisa. And thank you for your 10. And Paul Tucker, I understand, is the district attorney for Essex County, correct? And I guess he doesn't want to do anything about it. Crazy. Do you think it's crazy? Right. Kelsey's on house arrest. She can't go anywhere. Thanks, Nancy. And that's true, too. Max Bang. We got Tiny Jesus here. We got Tiny Jesus on our side. Here he is. And we have today's inspirational quote of the day. It is by spending oneself that one becomes rich. Sarah Bernhardt said that. It is by spending oneself that one becomes rich. Here it is. Daily motivation. And I love when it's on YouTube because we can pause and we can rewind. We can't do that on Zoom. And I don't have to worry that my voice is going to come blaring through the Zoom feed because somebody has me open in the background and they forget to mute. Yeah, they ran out of room on the call, right? They think their resources were stretched thin, Kim. You're right. Judge Drexler, says Mullen Law. He was awful. Hey, girl. Hey. Kelsey is in the front row with Courtney. Thank you very much. Free Billy Tibbetts. Free Billy Tibbetts. You know, Robin, I got a lot of hate mail every time I do that. It's a joke, first of all. Oh, I need my roots done. It's a joke because it happened during one of Karen Reed's Zoom hearings where somebody was on the Zoom call that didn't mute and was saying Free Billy Tibbetts. And I get hate mail every time I say that, even though it's a joke. People say that Billy Tibbetts is a really bad guy. It's like the Salem witch trials in Salem. Every time we go to Salem. Oh, look, that's right. There's the bingo drum on the windowsill. There it is. That's how they pick their alternates. Well done. Eagle eyes, law and disorder. Nothing gets by you guys. See it there? There it is. The old alternate picking bingo drum. Can't wait to see it. Learn about a little more about this new judge, Judge Karp. Is Kelsey going to go to the table? I don't know. I guess we'll have to see, Carrie. They wouldn't let her sit at the table before. Remember when she was behind the glass, when she was in custody, they wouldn't let her sit there. James says Scott McGinnis is there. There's the name placard for Honorable Jeffrey Karp. Kelsey is there. Kelsey's there. She's in the front row. She doesn't always get to sit at the table. Lawrence Superior Court. Isn't that what I said? Not District Court? Yeah, Lawrence Superior. But it was in the other building before, right? Essex has two different courthouses, two different locations, right? One is in Lawrence and one is in Salem. I think. I don't know. I know more about Massachusetts now than I ever have. Okay, thank you. So it's not Salem, it's Lawrence. How far away is Lawrence from Salem? No way. Jess Machado tweeted she was in the elevator and Brennan was there. Oh my God, did she get a selfie with him? Did she ask him any journalistic questions? I guess he had a case in the building. I don't think he's not involved in this one. This is not in Salem today, thank you. But it still feels like the Salem witch trials, doesn't it? Aylaian is sending great vibes to Kelsey today. Anthony Rose wants to know about the eyeshadow that I use. Couldn't find it on my Amazon link. Love it. Looking beautiful. You know what this is? You know what this is for real? Elf. It's like $8 at CVS or Walgreens, and they have really nice colors, and the pigment is great for on camera. There we go.
Good, how you doing? What's wrong, Brad? What's going to be coming in?
Court, all rise. Court in session, you may be seated.
Good afternoon, Your Honor. February 27th, 2026, 2 p.m. call of the list. Commonwealth versus Kelsey Fitzsimmons, 2025, 77 CR 311. The Honorable Justice Jeff Karp presiding. Could counsel please identify themselves for the record?
Good afternoon, James Gubitose on behalf of the Commonwealth.
Good afternoon.
Hello, Your Honor. Timothy Bradl on behalf of Kelsey Fitzsimmons.
Good afternoon. Good to see you.
Good to see you, Your Honor.
Good afternoon, Your Honor. Martha Coakley, also for the defendant, Kelsey Fitzsimmons.
Good afternoon. Good afternoon, Ms. Fitzsimmons. You folks can have a seat.
Thank you.
All right, so we're on for a scheduling conference.
Kelsey is now sitting at the defense table. Let me know that you can hear it, okay?
And a couple things.
Is Assistant Chief Cruz here somewhere? No.
Okay.
What's that?
Sorry.
Okay. I just want to make sure that folks in the audience and also the phone line is open?
Yes.
Okay. That folks in the audience and on the phone line just understand that there should be no recording video or audio images other than our media, registered media participants. Thanks. Now, if I have it correct, there's a final trial conference on March 12, 9:30. Is that right?
Yeah.
And the trial is scheduled for March 23.
Yes.
Is that right? Do you, roughly how long do you think the trial will be?
Well, I haven't received any witness list or anything like that from the defense, but probably 3 days maybe.
Okay. So, well, let me do
I
this.
agree with that, Your Honor.
Okay, let me do this. Let me tell you what I have for an agenda, and then you folks can, which is pretty straightforward, and then you folks can tell me what else we need to go over. So we have the schedule set. We'll have to decide whether there needs to be any other interim hearings. I wanted to talk about deadlines for those very things, trial motions, witness lists, proposed voir dire questions, etc. And wanted to get a sense of just kind of an overview, very brief summary, if there's any anticipated significant legal or evidentiary issues that you folks anticipate, because that may dovetail with our scheduling as well. To see whether there's any discovery-related issues. I know there's a motion filed by each side that's discovery-related. If I remember correctly, we can address those. And also something to get out ahead of time, to get out in front of that we can discuss as part of our deadlines, and that is whether there should be some kind of a media-related or spectator-related order, just so there's some procedure in place for any expected issues related to that.
What do you mean you want a buffer zone? A spectator-related order? Okay. The witness list hasn't been turned over because despite the Commonwealth filing their certificate of compliance, they have not provided the defense with all of the rewards, promises, and inducements that they've given to witnesses, including maybe their agreement not to prosecute Justin Aylaian. Hello.
And that's my agenda. I don't know if you folks had other things that you were anticipating or wanted to raise. Anything? No?
Dale?
Did I miss anything?
No, I think you covered it.
All right.
I do have a few things.
Sure, sure.
So we have a long list of things that we consider to be outstanding discovery. So I think we have a Rule 14 issue, and counsel and I have been going back and forth on it, but I don't think that there's been enough digging, frankly, about some of the stuff we're looking for.
All right, so I'll tell you what. So that will be part of our discovery agenda. All right, we'll do that. I'm not cutting you off. I'm just I'm trying to get an idea of what lays ahead. But yes, I do want to get out in front of the anticipated discovery issues, including the motions. Those motions that were filed.
Sure. And Judge, on that bail motion, I certainly want to give the Commonwealth time to look at it and react.
On the what?
The bail motion that I requested.
I saw something. I have not read it. I don't know if Mr. Gubitose shared. I had a charge conference this morning in a trial that's been before me for 5 weeks. It's going to the jury on Monday, and I just haven't had time.
Sure, I understand.
So if there was something filed this morning, I didn't see it.
Sure.
We can talk about that, but you said it's bail related?
It is, Judge. It just, whenever you're ready to address it, but there's just some pressing aspects of her.
I
think, so I have, I'll tell you this, I have read the materials that are in the file. I don't know anything else about the case other than what's in the file. But my memory is that, wasn't there a 58A order?
Yes, Your Honor.
And so if there's any changes that need to be made to that order, I believe the law requires it to go before the judge that imposed the conditions. Is the defendant out on conditions of release?
Oh, no.
She is, Your Honor. That's correct.
Okay. So
McCarthy Neyman's been taken off the case, Judge Karp. And in his defense, he's been on trial for weeks with the John Kerry case that I was just discussing before. That case is going on Monday to the jury. 86 murder of Claire Gravel. Let's see what he has to say about this. McCarthy Neyman's been taken off the case for reasons that may lead to some repercussions.
yeah, I mean, I
So that's going to trigger a recusal hearing, Your Honor. We have a request for an evidentiary hearing that Judge Ricciuti, the Chief Justice of the Superior Court, took over, and he ruled that my motion to recuse the prior judge was moot because she was not going to, essentially, because she was not going to be around in the sessions. So this is a...
Let me first get to this that you're talking about.
Sure.
Mr. Royan, let me get the motion. So this is paper 54, defendant's renewed motion for bail determination under section 5787 or chapter 276. So you say...
So we're asking for a revised bail determination. That's correct, Your Honor.
Okay. In other words, a change in the conditions of release or something?
Yes, that's correct. The document 51 in the docket, Your Honor, is our just filed. The prior substantive motion we filed was a motion to recuse Judge McCarthy Neyman from the case.
Okay. So let me first see if there's even an issue. So
Sure.
Mr. Gubitose, you presumably have seen this motion?
Yes, I got it late this morning.
All right. Leaving aside whether today is the appropriate time for it to be heard or not, what is the Commonwealth's position is? Should it be heard by Judge McCarthy or?
Well, yes. At the end of the day, there was a number of hearings in front of Judge McCarthy. The defendant appealed her decision to the SJC. The SJC denied the appeal, saying she did not abuse her discretion. That's where it stands now. Defense counsel did file a motion to recuse Judge McCarthy. As counsel said, can't remember the name of the judge.
Ricciuti? Okay.
Yes, deemed it moot because he asked her to get off the case. Not anything else, just to get off the case. That's what the defense counsel was asking for. Because she wasn't in the trial session and she wasn't going to be the trial judge, so none of that was acted upon. And so, but there's been an extensive history that the judge has dealt with, and frankly, I don't see a change in circumstances anyway. So,
Well, let me add.
I would point to document 51 for a change in circumstances, Your Honor, about the true nature of what's been going on in this case.
Okay, so let me say this. I like to have practical results and be pragmatic as pragmatic as the rules and the law allow me to. So I don't. Is it something that you would object to me hearing or something? If I have the legal authority, if you folks agree that I have the legal authority to weigh in on it, I don't know that today would be the appropriate day to do it or not, but we can talk about that.
I appreciate you being open.
Time is of the essence, Judge. Time is of the essence here. I'm going to show him a little bit of grace because he's been on trial for, what did he say, 5 weeks? And that's totally understandable. But he could be brought up to speed today. Gubitose should not oppose this judge hearing a change in the bail conditions, and he should be ready. He should be able to pivot. Gubitose, okay?
And I can narrow it, in terms of what I want to impose a little bit on the court and on counsel today to deal with is, some of these terms are duplicative and they're just bureaucratic. They're just onerous. And, 48 hours notice to make an appointment to come to my office. I don't know when I'm going to be in my office within 48 hours, and I need to have Ms. Fitzsimmons more at my, when I need her to prep. And so the idea of giving 48 hours notice to probation, to leave house arrest, to come to my office in Boston is just extremely onerous. You know, also, she's in the custody.
Let me just, so, because there's a couple different issues. One is whether, because I don't want to waste your time if it, in the sense that if it's something that does need to go to Judge McCarthy. So I guess what is the Commonwealth's position? Presumably the defense position is that I can hear it.
Yes.
And I should hear it.
You should. Well, our position is that she should be recused. We're more than willing, ready, willing, and able, and happy to have an evidentiary hearing on it. I don't think the Superior Court wants that on her recusal. And we think that the entire framework of this case has been an absolute circus from the beginning. And I'm glad you're here, frankly. And
whatever.
I have a pending motion to recuse. Well, not pending, but I filed a motion to recuse, Judge. And I am very unhappy with the way this thing has unfolded since arraignment. And we have moved to recuse. Judge Ricciuti, I think wisely, has made it a non-issue. And I want to forge ahead with Your Honor. And I want to go ahead with the case on all aspects with Your Honor. And I don't think it's in the Superior Court's best interest. I don't think it's in Kelsey's best interest. I don't think it's in anybody's best interest to kick this back to where it just came out of. And I just want to ask for a few things today. And I know that, you know, the court can say no, you got to wait. The Commonwealth can say no, you got to wait. But I think these things are not unreasonable. I just want to get rid of the 48-hour notice. I want her to be able to come to my office, get in a car and drive there on her own, like a grown-up. Her mom is the custodian of Ms. Fitzsimmons. Her mom works full-time. This has been an incredible hardship on her. She's got to drive her to my office and sit around for 3 hours. It's really unfair.
Let's do this. Let's do this. Before we end today, we will address whether I will address it or not. And the reason why is because I like to read it. When attorneys take the time, either side, take the time to write something and file it, I like to read it. And I haven't read it, and I
appreciate it.
I'm completely at a loss without knowing. So we'll need probation up here if we get to that point. But in any event, we'll circle back. I don't want to start on something that. Let's just start looking forward instead of back.
I love the idea, Your Honor.
We'll do that. So in any event, all right. So let's talk about legal and evidentiary issues, and just in the sense of deadlines. What I would like is a joint witness list, and you know, actually, like a joint witness list, because what I intend to do is treat this case like any other criminal case I preside over, and that is there will be individual voir dire, there will be attorney-conducted voir dire, and there will be a questionnaire. That's kind of my standard procedure. I won't keep Friday case in front of me, but I know your staff has, so.
I have.
Oh, you have?
Yes.
Oh, okay. All right. So
I guess
you must have done such a good job that I don't remember. But in any event, so that's where we're going, and so the reason why I bring that up is because one of the questions that will be on that case-specific juror questionnaire will be, do you know any of these potential witnesses? And what I like to do is just attach some Word document or something that has both of your witness lists, both of your witnesses on, both sides' witnesses on there. Also, on there we should list, the way it will be phrased is it will be potential witnesses and anyone possibly associated with the case. So if there's names of folks that their names may be prominent during the trial, some business may be prominent, I have no idea. Just, things of that nature should be just, the mechanism to do that is to put them on this, you know, potential witness list so that folks can flag it in their answer to the questionnaire. All right, so that's, and then also, frankly, I need to see a witness list sooner than later to make sure that I don't have any conflicts as well. And while I'm thinking of it, I will say this, it's not a conflict in my view, but I will raise, I did see in the file, I thought I saw a report from Dr. Zeisel, and was that on the defense side, right? Because you're
Yes, Your Honor, we have him.
before, right?
And that name didn't sound familiar.
No, okay. So I don't know if he's going to be a trial witness or not, but I will tell you folks, Mr. Gubitose may know this, I don't know. I used him a lot when I was a defense attorney. I've been on the bench 8.5 years, and I don't know if he's testified before me. I did keep in touch with him professionally for the first, it felt like the first year or two I was on the bench, just because I still had cases, there were still cases pending that I had been counsel on. But I don't believe I've spoken to him in 7 years or something, but I did want to disclose that. Again, I don't see a conflict at all.
This is what a judge is supposed to do. Avoid even the appearance of impropriety. This is what a judge is supposed to do. Listen, I see you have Dr. Zeisel coming in to maybe testify as an expert witness for Kelsey. When I was a defense attorney, used to use Zeisel years ago. Haven't spoken to him a long time, but both attorneys can waive that conflict and say, Your Honor, we're fine with it. But this is the way a judge is supposed to behave. Dr. Zeisel, that's the expert witness psychiatrist. He's also, I think, the expert in the Lindsay Clancy case, by the way.
But you folks can think about it. And do you expect that he'd be a witness?
So, Judge, we're sort of on the fence about it, actually. That's the number one area that we're on the fence about. But if you don't have a problem with it, we certainly don't have a problem with it.
Yeah, I don't, but you folks will let me know. So on the legal evidence, what motions, what unusual trial motions should I expect, if any?
I don't think there are really any unusual ones, like bad act motions, things like that.
Yeah.
Nothing unusual from the Commonwealth side. With the caveat that I don't know who their witnesses are or whether they're going to be calling an expert, and that's one of the things I think we need to address today. So.
Oh, okay, yeah. That is a good point. So, because if there's going to be a mental health defense, so I want to keep this case on target for March 23 because.
Agreed.
From my perspective, and I'm sure everyone agrees, if it's not March 23, then that's to the extent that the case is assigned to me, and I don't know if that's been formally done or not done, then I'll be off to a civil session for 3 months, and we'll be waiting. So we've cleared the deck, so to speak, for March 23. So I'd like to make sure that we're on target to do that. But things like mental health defense could slow things up if the Commonwealth wants to hire their own expert, et cetera. So
I understand, Your Honor. So I think the Commonwealth has Rule 14 problems, though. They've got to comply under Rule 14 before we have to do anything. And I have a list of, and I know Commonwealth's been trying to kind of work with me, without bothering the court, which is always the best way to go on these things. And, we're sort of getting there, but it's going very slow. And I have a list of about 8 things here that, make their certificate of final discovery compliance really not accurate.
So can I ask, I thought I did see, Mr. Gubitose, from your perspective, is it the Commonwealth's position that you folks have complied, or are there still outstanding discovery issues?
I think the only outstanding discovery issue, and I did reply to defendant's request for his 8 items the other day. I hope he got my reply. It is the ones that we're going to talk about this afternoon.
Okay.
So other than that, there is maybe an issue with I have to provide him a link to something. But other than that.
Okay. All right. Well, I'll tell you what. I put it on the agenda. Let's get right to it. What are the discovery issues?
So Judge, today,
And did you say that there was a certificate of compliance filed? Because I should.
the last date, Judge, right, and,
Mr. Wayne, do you have any idea what, I'm sorry, 50? I'll just get that out, find it. Okay, go ahead, Mr. Bradl.
Thank you, Your Honor. So Judge, today, the Commonwealth is giving me a surveillance system that was taken out of the house. So I appreciate that. We've been looking for that. There's some video.
What do you mean?
So
they produced the actual.
They took the actual system, right? And we need it for some other cases as well. And we've gotten that taken care of today. The Commonwealth's going to give me that system today. Expert notice. Okay. So
Did the camera person fall asleep? What are we looking at here? The Commonwealth took the surveillance system out of the house, apparently, and they just gave him some more footage. Okay, just a reminder, the Commonwealth isn't supposed to file their certificate of compliance until they have turned over all automatic discovery. That's a certification that they're done turning over everything that they were required to turn over to the defense. And that is when the defense's time starts to run, that they need to turn over discovery to the prosecution. So let's listen to this again.
right, and
Mr. Wayne, do you have any idea what? I'm sorry, 50? I'll just get that out. Find it. Okay, go ahead, Mr. Bradl.
Thank you, Your Honor. So Judge, today, the Commonwealth is giving me a surveillance system that was taken out of the house. So I appreciate that. We've been looking for that. There's some video. So I appreciate the Commonwealth is giving me a surveillance system that was taken out of the house. So I appreciate that. We've been looking for that.
They've been looking for that. When did they take the surveillance system out of the house? Well, I guess that's why Kelsey's dad didn't have access to it, because the Commonwealth stole the surveillance system. So they knew all along that they had this footage. When did they take it? Or was this the footage that we saw yesterday from July 3rd, 3 days after Kelsey was shot in the chest, of Justin breaking into the house with his 3 buddies? Was that only from the new cameras that her dad had installed? This is what I do here. I stop, I pause, I comment, I explain things to you as they go along so that we don't have to rewind later and redo the whole entire thing. And if you don't like it, there are other places you can go watch. Don't put your mean comments in all caps. I love you, but it's not a compliment.
There's some video.
What do you mean?
So
they produced
the actual. They took the actual system, right? And we need it for some other cases as well. And we've gotten that taken care of today. The Commonwealth's going to give me that system today. Expert notice. Okay, so under Rule 14, I don't know. I don't think we have the proper expert notice in terms of the CV and who's testifying as an expert and what's the opinion going to be. I don't know if, I don't know that I have everything or on that. And I'll elaborate on that a little bit as well.
Okay, well, let's just take them one at a time. So what kind of experts would there be unless there was a mental health defense? You're talking about like ballistics or something?
Yes, ballistics.
Okay.
I turned over the CV to defense counsel. It's on Axon. He has the report of the ballistician who analyzed 3 guns and says that 1 gun matches the shell casings that were found on the scene. Other than that, I don't see any other.
But this isn't, the defendant's not charged with a firearm offense, right? It's ADW, is that?
So here's where I'm going with this, Judge. We're sort of talking about 2 separate things. The Commonwealth has given us a 7-page report, and the report concerns the guns that the responding officers had. It lists 3 Glocks, and they're all the service weapons of the responding officers. So that's great. I'm not interested.
No, that's incorrect. And if defendant, I sent an email to him, February 6th, because we had talked about this. I hate to interrupt, but he's just wasting his time.
I hate to interrupt, but he's just wasting his time. Boy, could you imagine working for the PR team at the Essex County DA's office right about now after all of the explosions that happened yesterday with Justin breaking into the house? Apparently, Tim Bradl wants to hire a ballistics expert to come in and talk about the guns that were used by the officers in this case. Hate to interrupt, but I'm going to do it anyway because I don't want him wasting his time. I don't care if you like it or not. I'm rewinding. My chat, my choice. Here we go.
Responding officers had. The Commonwealth has given us a 7-page report, and the report concerns the guns that the responding officers had. It lists 3 Glocks, and they're all the service weapons of the responding officers. So that's great. I'm not interested.
No, that's incorrect. And if defendant, I sent an email to him, February 6th, because we had talked about this. I hate to interrupt, but he's just wasting his time.
Yeah, go ahead. I'd like to hear it. Go ahead.
And in the email, I talked about which gun was which gun. There was 2 officers who were on the scene. One, the shooter, one Officer Noonan, who discharged his firearm. Another.
He just said one is the shooter. That's right. He was the shooter. He was the shooter. He's the one who shot Kelsey in the chest. And check it out. He's going to walk it back. I mean, he's the one who, no, there were 3 officers in the house, sir. We know, we have the reports. Listen.
One, the shooter, one Officer Noonan, who discharged his firearm. Another officer who did not discharge his firearm. And the gun that the defendant is alleged to have. Yes, who is alleged to have. And that was her service weapon. And I detailed for that to defense counsel. And so the analysis that was done on the gun that was involved in the shooting. So that's all.
So this would have been, what was the officer's name?
Noonan.
This would have been Officer Noonan's
Noonan.
service weapon.
Yes, and so I had sent an email because we had been talking about that on February 6th concerning that exact issue to clarify for defense counsel.
Okay.
So,
yep, go ahead.
I appreciate counsel interjecting with that. And if it's, I'll go back and look at it, but I read it to be the 3 officers that were at the scene and that their guns were taken pursuant to protocol. But if the Commonwealth is saying that that's the gun that was used, then that's fine. And I'm satisfied with that. I didn't read it that way, but if that's how the Commonwealth has it, I'll go back and look at it, and that's fine. So that's we can take that one off the list.
Okay.
Body-worn cameras, Your Honor. There were an officer visited Ms. Fitzsimmons early on when she was at Mass General Hospital. She spent 53 days at Mass General. An officer visited her there. And I don't know if there's a report that emanated from that or a body camera that emanated from that. And then,
So when you say body camera footage, it's very narrow. You're saying like
Right.
there's a specific event or
right, it was one officer that visited her at the hospital, right?
Okay, and was this a social visit or something?
That's a good question. It might have been half and half. I'm not sure.
And would this have been a North Andover officer?
Yes.
State police. Okay.
Yes,
So,
sir.
and have you?
But we've been told that North Andover police don't wear body cam footage, don't wear body cams. So they didn't wear body cams when they came to serve her with the restraining order and the take her baby away order. But maybe there was an officer who visited her at Mass General and was wearing a body cam, and it could have been a social visit. It could have been something else. This court officer in the background is all of us right now. Watch his facial expressions.
Told the Commonwealth the identity of the officer and the service?
It actually might be the trooper.
Oh, okay.
If I could just have one moment. Sure.
Yeah, please. If it's MSP, we know I think they wear body cam. Kelsey chiming in to Tim Bradl to tell him who it was that visited her in the hospital.
Detective Dan Furman.
And I don't. Who is that?
So he visited Ms. Fitzsimmons at the hospital, and if there's any.
I'm sorry. I meant when I said who is that, I meant what police agency?
MSP?
So there's a visit from someone who's might be a social visit or a police visit. I don't know what it is, but I'd like to know if there's any documentation of it.
All right. So this, but again, this person's name, this officer, detective's name.
Furman, F-U-H-R-M-A-N.
Okay. And
There's a Furman involved in this case, but because of course there is. Remember Detective Mark Furman from the OJ case? There's a guy, his name is Dan Furman, and now Furman has entered the chat. Same spelling, F-U-H-R-M-A-N, because you know why? Because you can't make it up. Here it is.
I meant what police agency?
So there's a visit from someone who's might be a social visit or a police visit. I don't know what it is, but I'd like to know if there's any documentation of it.
All right. So this, but again, this person's name, this officer, detective's name.
Furman, F-U-H-R-M-A-N.
Okay. And what police agency does he work for?
North Andover.
All right.
Wow.
And so this should be, well, and you're saying that you don't know if it was a social visit or not?
All I know is the North Andover police officer visited her, and is there any documentation of it, or is there a report? Is there a text message from it? Is there anything from it? I just want to know.
Wow. Do you think North Andover PD sent somebody in there like a mole to feign concern for Kelsey while she was in the hospital to try and get some information out of her and maybe was wearing body cam? Wouldn't that be interesting and a turn of events? And again, look at that court officer in the back. I don't want to get him in trouble, so I'm not going to point it out again. North Andover PD, what do you think?
I'm not expecting any answers right now. I'm just, do you want to weigh in on this?
No, this is the first I've heard of it, and I would think the defendant would know if it was a social visit or anything more than that. I don't believe North Andover has body-worn cameras, but I will certainly make an inquiry. This is the first I've heard of that. So.
All right.
And then and there's also a body-worn camera from Ms. Fitzsimmons' arrest at the hospital. She was arrested at the hospital and kind of cuffed to the bed, and pursuant to the district attorney's office wanting to move the case along and get her arraigned. And there should be body camera from the state police from that.
All right. So is it?
And I believe that's Trooper Strong.
Is this request been, are you familiar with this, Mr. Gubitose?
My understanding that defense counsel called me and asked that there not be body-worn camera when the state police went to her. So, but I will double check that. So.
Okay.
My client tells me that there was body-worn camera that was activated, and that she was informed that there was body-worn camera.
Okay. Well, if there was, then it sounds like it wouldn't have been North Andover. So
No, that's state police.
State police.
That trooper is here today. I'll ask him.
Okay. All right. And you know what? Excellent. Because if the troopers here, to the extent that we can put any of these issues to bed today, that would be great. So what else?
Promises, rewards, inducements, Your Honor. That's the subject of an entire filing today.
Okay. So we will. Do you want to do that now, or do you want?
Yes.
What else is? Well, what else is on your list? We'll circle back.
That's the list, Your Honor.
Okay. All right, but I want to make sure I'm not missing anything, because didn't you say that you had 8 things and I only had 4?
So I'd like a witness list from the Commonwealth. I'd like to move to strike the certificate of discovery compliance to the extent that it triggers our obligations when their discovery obligations are not satisfied.
And by the way, Attorney Coakley, I don't have these rules about, I have a case in front of me now where there's 3 DAs and 3 assistant DAs and 1 defense attorney. They're all welcome to speak. So to the extent that I'm not, I don't have rules against more than 1 attorney speaking. So
I appreciate that, Your Honor. I'm not afraid to speak. And
No, you're not afraid at all, but I don't want you to, anyone to think that, to the extent that you want to be heard, you can be heard.
thank you. I appreciate that.
What else?
Judge, there's also some OneDrive links that I know that I think the council referred to that. There's some OneDrive links for some discovery that we don't have. That we got some Axon discovery that had OneDrive links in it, and it was not communicating very well with our computer. So council is going to get me OneDrive links for, I believe,
Kelsey writing notes. Martha Coakley is no wallflower.
So I'm actually at a loss to say what's on these OneDrive links because I can't open them.
Okay, all right, well, that's, Mr. Gubitose, do you know anything about this?
Yeah, as I had said just a few minutes ago, I understand what he's looking for. I understand, and we'll send him the link on Monday.
Okay. All right, what else? Mr.
I
Bradl?
believe there were some redactions in the grand jury minutes that were given, Your Honor. And if there are any redacted grand jury minutes, we need the unredacted grand jury minutes.
I've never heard of that. But
Right, I
is that
think,
what-
yeah, it was strange.
No, and I tried to explain this to Howard when he got a redacted exhibit that I used in grand jury. And it was an interview with some of the officers that talked about things that I thought were too prejudicial to the defendant. And so I submitted to the grand jury for their consideration the redacted exhibits.
Okay.
However, he has the full exhibit also, meaning a full unredacted version of those recordings.
Okay.
Okay, stop. You redacted portions of the grand jury testimony because in your mind, you thought they were prejudicial to Kelsey Fitzsimmons, the defendant. I'm sorry, what? I've never heard of that either. Were there shenanigans going on in front of the grand jury too? Like in the Karen Reed case? Like in some of the other cases that we cover? Like in the Turtleboy case? Shenanigans? Tomfoolery? Ballyhoo? Another courtroom where the prosecutor's bench is attached to the judge's bench as if they are one. Let's hear that again. They're entitled to all of it. Too prejudicial to who? The officers that testified or to Kelsey? There he is. There's my new favorite court officer. He is all of us right now. Look at his, if you can come look at your screen, please do. You don't want to miss this.
Interview with some of the officers.
Yeah, it was strange.
No, and I tried to explain this to Howard when he got a redacted exhibit that I used in grand jury.
Redacted
and
exhibit?
It was an interview with some of the officers that talked about things that I thought were too prejudicial to the defendant. And so I submitted to the grand jury for their consideration the redacted exhibits.
Okay.
However, he has the full exhibit also.
So the grand jury got redacted exhibits, which were interviews with officers. And this Mr. Gubitose, counselor, redacted certain portions of it for the grand jury because he felt it was too prejudicial to Kelsey. Okay. But he says he gave Tim Bradl unredacted copies. Okay.
Meaning a full unredacted version of those recordings.
Okay.
Recorded.
So the grand jury minutes themselves, I'm sorry to interrupt.
No.
I'm not redacted.
So they actually recorded the police officers' statements. That's a new one. No body-worn camera, but they recorded the police officers' statements. But in his mind, some of that, what they said was too prejudicial to Kelsey. So he didn't let the grand jury hear it. Okay. Cool.
Okay. That's, if I have it, I'd like to have it. And,
Yep.
Okay.
you know,
So, yeah, I mean, it sounds as though Mr. Gubitose has produced them, and I'm sure will, if not, with both the redacted and the unredacted versions, so you'll have a record of what exactly the grand jury saw, if you don't already.
Thank you.
What else?
The rest is the promises, rewards, inducements motion, Your Honor. There's two key pieces here that are.
All right, so we're ready to go
Yes.
to the motion. All right, so let me just cue that up. Where's my notes? So it's been docketed as paper 53, defendant's motion for disclosure of promises, rewards, and inducements. And I have read it. I've read the attachments, and I don't know if this is an issue for Mr. Gubitose or not. But I'll say that the problem that I saw with the motion is that it's not supported by affidavit. And I don't know, again, if that's something that the Commonwealth would raises or not. But to the extent that you're relying on statements of your client and your client's father, I typically would see that in an affidavit form. Is that it?
Well, Judge, I do have an attorney's affidavit, and I do at the end of the motion, but I do view it more as like a,
Somebody's phone went off.
what we're doing here from the defense side is we're pointing the Commonwealth to specific exculpatory evidence.
Right.
So, you know, whether, how far we have to go with affirmative, you know, averments of that, you know, I don't think it's not like a motion to suppress where we're asking for the court to, you know, make significant rulings. This is a notice to the government that says, hey, look at all this stuff that has happened. And, you know, you need to figure this out. And I think that the government, in this case, with respect to this Aylaian guy, has rose-colored glasses on where they're like, you know, they don't want this guy to be harmed. They think this is a probate court issue. They think this is, oh, just, you know, just focus on Kelsey. Let's not worry about this guy. Don't look over here. Don't look behind the curtain. So this is an incredibly egregious thing this guy did. Ms. Fitzsimmons was in the hospital fighting for her life. That was her home. He had gone and gotten a restraining order in which he swore in the affidavit, I don't live there. I live in Stowe with my parents. He's now a plaintiff against Ms. Fitzsimmons as a defendant in a restraining order matter. He has no rights to that house whatsoever. 3 days later, her dad, who's a security expert and owns a security business, changed the locks, updated the security system, made his daughter's home secure again after this thing happened to her.
And after the shooting.
After the shooting, and she's in the hospital. She's away from her house. And this guy takes advantage of that to commit all sorts of serious crimes. He's on video breaking into the place with 3 other friends, 3 other accomplices, bust down the door, come in, it's on video, it's in an exhibit that you have, and he commits all sorts of serious crimes. The most serious one for purposes of this case is that he stole evidence. He stole evidence off the refrigerator. It's a felony. He had just...
Can I ask you something?
Yes.
Assuming everything that you say is true, the motion is for promises, inducements, or rewards. So your theory is what? That the Commonwealth promised to not charge this guy or something?
Yes. That's exactly what we think. And he's a precipitated witness. He's at the scene of this shooting, Your Honor. He's at the scene of the shooting. This isn't about, 3 days earlier he did this order. It's that he's a precipitated witness at the shooting. He's there. He and his sister are there.
At the end of the day, the motion is for promises, inducements, or rewards. So
Yes.
As those terms are understood, has the Commonwealth made any of those or offered any of that to this gentleman?
I think I can answer it this way. Okay. As far as him being a recipient witness, and you don't know very little about this case, the 2 people who were there in the room when the shooting occurred, when the allegations against the defendant pointing the gun at Officer Noonan and pulling the trigger, and him shooting her in self-defense, the 2 of them are up there. That's in the top floor bedroom. Mr. Aylaian was in the basement at the time. He's on surveillance video in the basement. He hears it, he leaves. So he's not a recipient witness. I'd just like to put this up there. That the case does not rise and fall on him. He might be a background witness. He heard the shots.
Wow.
But as far as what happened in the bedroom, he has no idea. So to say he's a critical recipient witness, I would suggest is a little misleading.
A little misleading. Kind of like how Cosgrove was arguing that Lindsay Catani is not a recipient witness. We don't really need her. We don't really need her, so I don't have a conflict. He was in the house because your officers told him to come and pick up the baby. He was on notice that they were going to serve her with this restraining order and take away the baby order, and he was in the damn house. But, you know, give us some word salad and spin it around. And he still broke into her house and stole evidence with the air quotes, right? Stop with the air quotes. None of this happens without his fraudulent order. Thank you, Julia.
Now, if
No,
it's
and
critical or not, there's either.
And I agree.
Okay.
And, but I just have to correct the record.
Sure.
Now, defense counsel sent my office a packet of information, including, and we have the video of, oh no, we didn't have the video. He sent video of Mr. Aylaian, I'm going to call him Justin, I apologize. I'm having trouble with it.
Aylaian.
Entering the house on a specific day. And the Commonwealth, and what is omitted from the defendant's argument, and he has this, and he knows that the day before this happened, Justin called the North Andover police and asked if he could enter the apartment. He told them that the defendant was on the deed, but he had property there. And they told him he could go in.
Bullshit.
On the next day, with his
Bullshit. They told him he could go in the house. Bullshit. They're not married. The house doesn't belong to him. She's fighting for her life in Mass General. They would have absolutely mother effing escorted him there to get his stuff. How dare you? Give me some how dare you emojis in the chat. Are you kidding me? When Kelsey's father went there, he went there with a police escort. He saw the house had been broken into. He said somebody just broke into the house. Justin came up with his buddies and said, oh yeah, that was me. Are you kidding me? The North Andover Police Department is the reason that Kelsey was in the hospital. They shot her. She was also a North Andover police officer. Are you kidding me? I can't wait to see. We're a little behind. No spoilers. I can't wait to see how he responds to this, because if it was me getting up and screaming like I am right now, they would be Brian stealing me in handcuffs and taking me out of that courtroom. How dare you? His name was nowhere on that house. He was her ex-fiancé. He's the reason she's in the hospital. And he swore to a court that he lived at his mother's house in Stowe. Are you kidding me? Wow, sir. You got some really big ones. You got some really big ones. We got to hear that again. You can't even pronounce the guy's name. It's Aylaian. Just in it for the money, Aylaian. Wow.
He has this, and he knows from a specific day. And the Commonwealth, and what is omitted from the defendant's argument, and he has this, and he knows that the day before this happened, Justin called the North Andover police and asked if he could enter the apartment. He told them that the defendant was on the deed, but he had property there. And they told him he could go in. On the next day, where this video is, he calls again and says, I need to go into the apartment to get my stuff. He asked for a police escort because he's afraid of what the defendant and the defendant's family would do if he went in there. He was worried about his in his words, vengeance. Okay? And so
you and your goddamn air quotes. The vengeance was getting the restraining order and the take away the baby order against Kelsey in the first place because she broke up with him. That's the vengeance, sir. Oh my God, they should dismiss this case right now, just based on this man's audacity and attitude. And if the North Andover Police Department is allowing him and telling him to go on over there and get whatever you want and break the door down, they should all be in handcuffs. This is outrageous. Why was the North Andover PD or whatever police department escorting her father there and not him on the same day? Isn't that a little too coincidental? Bullshit. You got a police report on that?
And says, I need to go into the apartment to get my stuff. He asked for a police escort because he's afraid of what the defendant and the defendant's family would do if he went in there. He was worried about his in his words, vengeance.
He already moved out.
Okay? And so he does go in. He does push the door open. He goes in to
he broke in.
Retrieve his items.
With the police escort?
No, the police didn't come. At that point, the alarm went off because I'm assuming there was some surveillance video in there and an alarm system.
Sure.
When the alarm goes off, he calls the police and he says, can you come here, please? The alarm went off. I'm worried that the family of the defendant will come, and I'm worried.
Oh my God. Oh my God. I can't believe this bullshit. We saw the surveillance video. He breaks the door down with his three buddies at 9:35, I think, in the morning. He's in the basement by 9:36, ripping out the alarm system, ripping out the surveillance system, ripping the modem off the wall. Within 1 minute of them breaking into the house. This, dude, I don't even, have you even watched the video? Wow. Wow. It is, the corruption is now in your face. It's in your face. This is going to delay discovery now. Now they need all the call logs. They need all the reports. They need everything because this is complete horseshit.
Can the police, can you come here, please? The alarm went off. I'm worried that the family of the defendant will come, and I'm worried what will happen because they're very vengeful about the whole situation.
They're vengeful?
And they said, we're not coming, but if he shows up, let us know, and we'll come and keep the peace. He then gathers.
The family is vengeful? The family is vengeful. Dude. You had her baby taken away. You had her breastfeeding 4-month-old infant taken away based on your ex parte bullshit. And her family's the vengeful ones? Okay. This is not going to go well for you. This is not going to go well for you, Gubitose. I think that's who this is, right? Listen to this again.
The defendant will come, and I'm worried what will happen because they're very vengeful.
They're vengeful.
About the whole situation. And they said, we're not coming, but if he shows up, let us know, and we'll come and keep the peace. He then gathers his belongings and left.
Okay.
So we can't look at a crime. The Commonwealth, in any case, does not look at a crime in isolation. We have to make determinations when we're looking at cases. Okay. Justin has also filed an affidavit in court.
Why is Justin being protected? Why is Justin being protected? If every mainstream media is not on this today, my head is going to pop off. And it's going to be in Canada in the next 10 minutes. This is insane. You have an affidavit from him that says what? Wow. You didn't turn it over. That's why they had to make a motion for promises, rewards, and inducements. Why didn't you turn it over? We have to look at a crime in isolation. We have to make decisions on whether or not we're going to prosecute. Oh, again, the court officer, my freeze game is on point. Yeah, you made a determination to prosecute Kelsey instead of Noonan. And now you made a determination, apparently, not to prosecute Justin it for the money. Okay, I see what's going on here, and it's in your face, and you should see it too, and you should be outraged. Wow. We're not coming, but if he shows up, let us know.
We can't look at a crime. The Commonwealth, in any case, does not look at a crime in isolation. We have to make determinations when we're looking at cases. Okay. Justin has also filed an affidavit in court.
In this court or in the?
No, in the probate court, as the restraining order, which 3 judges have not been found credible. And the defendant has yet to litigate that motion. And so we have information from the defense about what happened, about this breaking and entering in this
Did he just do air quotes again?
Theft of evidence.
Again, with the air quotes. Are we in the 80s? Are we back in the 80s now, sir? Hold on. I can't even believe, my jaw's on the floor.
In this court or in the?
No, in the probate court, as the restraining order, which 3 judges have not been found credible.
Wait a minute, what?
In any case, does not look at a crime in isolation. We have to make determinations when we're looking at cases. Okay. Justin has also filed an affidavit in court.
In this court or in the?
No, in the probate court.
In the probate court, he filed an affidavit. Yes, remember, and that was the same day that Kelsey was shot. June 30th of 2025, the last day that she saw her baby, the last day she was able to breastfeed her baby. He filed a bullshit affidavit in the probate court. Kelsey has missed her child's christening. She has missed her child's first birthday. She has not been able to bond with her child or seen her child since June 30th. And you're relying on an affidavit that he filed to get custody of his child and to get a stay away order against Kelsey. And when he did that, and when the North Andover PD were going to serve that order, he warned them. He said, listen, when you serve her with this order, she might try and harm herself or the baby. So, were any of those guys who broke in with him North Andover police? Were any of them North Andover firefighters? I have so many questions. You're relying on an affidavit from June 30th? Okay, go on with your bad self and your air quotes.
As the restraining order, which 3 judges have not been found credible.
There's never been an evidentiary.
And the defendant has yet to litigate that motion. And so we have information from the defense about what happened, about this breaking and entering and this supposed theft of evidence, and that's the first I heard of it was evidence. And we have that packet. We reviewed it in an abundance of caution. We asked Middlesex to look at it, and they were going to take a look at it. At that point, Attorney Coakley called Middlesex, the first assistant, about that. Middlesex then called us and said, we can't do it. We don't want to take a look at it. We think we have a conflict now. So our office then looked at it, and we determined that we are not going to charge Mr. Aylaian for these.
Oh, okay. So you thought that you had a conflict. So you called Middlesex DA to see if he would prosecute Justin for the money, Aylaian. And Martha Coakley called Middlesex to say, you can't take this case because you've got a conflict. So then we looked at it again, even though we thought we had a conflict. And then we decided we're not going to prosecute. Do you see what's going on here? We don't even know what is going to happen to Judge Kathleen McCarthy Neyman and why she was so quickly pulled from the case. And they closed the curtains on that because of her ex parte communications, maybe with probation and complaints against Tim Bradl. This is outrageous. Listen to this again. This is how you spell corruption. Thank you, BN Trouble 31. And it's in your face now. It's in your face. It's undeniable. It's undeniable. How are the trolls going to spin this into a positive?
We reviewed it in an abundance of caution. We asked Middlesex to look at it, and they were going to take a look at it. At that point, Attorney Coakley called Middlesex, the first assistant, about that. Middlesex then called us and said, we can't do it. We don't want to take a look at it. We think we have a conflict now. So our office then looked at it, and we determined that we are not going to charge Mr. Aylaian for these crimes. I don't know if he even knows.
He just called him Mr. Aylaian. Listen.
The office then looked at it, and we determined that we are not going to charge Mr. Aylaian for these crimes.
Aylaian.
I don't know if he even knows that this is out there. I don't know if he even understands that there are charges, that the defendant is.
Captions got it right, Mr. Aylaian. You don't even know if he knows it's out there. Oh, he knows, sir. We broke this yesterday. It was broken on the internet before I covered it live at 4 p.m. yesterday. And you can bet your ass he knows about it now. And he only took Kelsey's things from Kelsey's home. It's not an apartment. It's a home.
Alleging occurred, that knows that this is out there, that we are not going to charge Mr. Aylaian for.
That's an inducement and a promise. And you're required to disclose that to the defense. And you didn't. And you filed your certificate of compliance fraudulently without disclosing that to the defense. Can you say Brady? Hello? Where's Howie Carr? Where is Howie Carr? Paging Howie Carr.
For these crimes. I don't know if he even knows that this is out there. I don't know if he even understands that there are charges that the defendant is alleging occurred. I haven't talked to him about that. If I do, and if he has a concern, I'll tell him that we're not charging him with that based on the entire circumstances of this.
And there you have it. They are not charging him with that. Even though you have a conflict and you referred it to Middlesex out of an abundance of caution, you're not going to charge him. And you didn't think to disclose that to the defense. Wow, just effing wow, dude. I don't even know what to say. I don't even know what to say. Let's keep going. I haven't talked to him about that. But if I do, I'll let you know. No big whoop. No biggie.
There are charges that for these crimes. I don't know if he even knows that this is out there. I don't know if he even understands that there are charges that the defendant is alleging occurred. I haven't talked to him about that. If I do, and if he has a concern, I'll tell him that we're not charging him with that based on the entire circumstances of this case. The Commonwealth is often in the position of
Wait.
analyzing cases when there are dueling.
Wait. So you were aware of this. You had the video. You decided not to press charges against Justin Aylaian without ever interviewing Justin Aylaian? Did you just hear that? They didn't even interview him. I have no words. I have no words. This is corrupt Massachusetts. This is Massachusetts. This is where your constitutional rights go to die. And this is where district attorneys who have a conflict send it to a different district attorney who has a conflict, and then they take it back and look at it despite their conflict, and they decide they're not going to press charges against Justin Aylaian, because that's what he called him, without even talking to Justin Aylaian, and they don't disclose that to the defense. What is happening? Let me tell you what, if you're watching the Corey Richards trial today, you are missing out. And if you're on the replay, hype the video, please, and like it. Thank you.
Issues and dueling statements. And we have an obligation to parse those out. And if we don't believe there's probable cause, we don't charge. That's what we have here. The Commonwealth has made the determination, not in isolation, but in the whole circumstances of this case, that we are not going to charge him. If at some point during the case, Your Honor thinks he has a fifth, we'll immunize him. But we haven't told him that. Defense counsel is now on notice that that is our position. So is it a promise, award, and inducement? It is what it is right now. Okay. So they're on notice of that. All right. So
he used air quotes. They're on notice of it because they found the flippin' surveillance video. This is like The Handmaid's Tale. It's like The Handmaid's Tale.
So, Mr. Bradl,
yes.
Let me see this. So the whole idea of the of discovery, obviously disclosure. It sounds like perhaps this is the first time you've heard the full version from the Commonwealth's perspective. But to the extent, now probably isn't the time to determine whether it's a promise, inducement, or reward. I think now is the time to determine the sufficiency of, assuming that it is one of those three things, the sufficiency of the notice provided to you.
Absolutely, that's what we're interested in, Judge.
All right, so
communications.
all right, so it sounds as though so what is it further that you're looking for? You want something in writing that they're not going to?
So just a couple of quick things, Judge, as far as you're almost said. I have the call that he made to North Andover, to to one of the sergeants up there, I believe Sergeant Gerke, I may not be saying her name right, but we have the call. And in the call, he's committing another felony called misleading police. He's saying to her that he still lives there and that he wants to get in there, and he's looking for a dispensation from them to let him get in there. And he lies to her, and he says that he still lives there. Completely contradicts what he already swore to the probate court judge, family court judge, to get the restraining order. And so the sergeant, I think, does the right thing and says, well, if you have a key, or, if that's your house, I can't stop you from going in your house. But she doesn't say, yeah, you go right ahead and go in the house. She's deflecting and saying, well, you're telling me you live there, I can't do anything about it. So it's this sort of round and round conversation where he's trying to get dispensation from them, and she wisely just says, well, if it's your house, go ahead, but I don't have anything to do with it. That to me is the gist of the conversation that I have. So there's yet another crime that they're looking the other way on for this guy. But in any event,
Mr. Bradl,
so I'm sorry, Judge, I'll tell you what I'm looking for, okay? That's it, please. All right, I'm sorry. So I'm looking for text messages, emails, notes to, what is the police, what is the DA's office, what are they saying about this incident that they know about? Are they saying, don't worry about it, we're not going to prosecute you? I want the communications. What are they saying? I can't, it's always hard from a defense perspective to, guess what's out there. They should be giving me, here's all the communications about Aylaian and him breaking into the house and why we're not prosecuting him. And this whole business about that, he checked with the police, he lied to the police. So he didn't check with the police. So their facts are all wrong. And, he should be prosecuted, and they're in a conflict of interest, and the court should direct them to appoint a special prosecutor because they clearly have a conflict of interest in trying to prop this guy up for their own case. And so they ought to be ordered by the court as a matter of ethics, as a matter of appropriate behavior as an attorney to appoint a special prosecutor. And I want to ask the court to take a serious look at that.
Let's do this. Can you, can Ms. Fitzsimmons as well, come on over to sidebar for a moment.
Oh, yeah. He told us everything. Scott McGinnis, I think, is in the courthouse. Oh, we can't have that. Seeing Hank Brennan leave the courthouse makes me wonder why he was here now, says Scott McGinnis, boots on the ground. We're a little bit behind, so we have a little room to move here. Okay, let's see what happens here. Now we're almost on. After the sidebar.
All right, so as we discussed, the Commonwealth has made a disclosure. To the extent that that can be defined as a promise, reward, or inducement, I'll leave it to better legal minds than I. If the defense feels as though, as it relates to that particular person, Mr. How do I pronounce it? Aylaian? Aylaian. Okay.
Aylaian.
As it pertains to Mr. Aylaian, that the defense needs something further, then you'll have to just put it in a motion or a letter. It won't be a motion if you don't need to bring it to my attention, and we'll.
I'll memorialize it.
Okay.
And then, Judge, just to close the loop on that, so there's also the same issues relative to Officer Noonan.
Right, which is the second part of your motion.
Yes.
So let's hear that.
All right, thank you, Your Honor. So, Judge, we're pointing the Commonwealth to more specific information relative to all sorts of special treatment that Noonan is getting above and beyond, what is essentially in North Andover police policy. There's been misconduct that it may have been overlooked. We're asking for the discovery, so we shouldn't be in the position of saying, here's everything we exactly know 100%. We get all sorts of information. We investigate our case. And so we point to the Commonwealth and say, we're not getting the whole story here. We're getting all sorts of background information. We're pointing you to the North Andover police and what happened with this guy being AWOL and being forgiven. What happened with this guy and drug issues that may affect his ability to perceive and recollect the trial.
Here's the thing, from a discovery perspective, at least from my perspective, is it sounds like that's a Rule 17 issue, right? It's the
prosecution team. Sorry to talk over
this. Just let me tell you what my thinking is from reading this. It sounds to me that without condoning or weighing in on it, just again, that the issues related to the way that the North Andover Police Department did or did not treat the officer that was involved isn't something that the Commonwealth, these are not members of the prosecution team that are, presumably, again, that are making decisions related to the treatment of Officer Noonan, which I assume is the subject of a collective bargaining agreement, which I think you may have even attached something. Or I saw somewhere in the file, I don't know if it was with this. So again, to the extent, and I'll hear Mr. Gubitose, to the extent that members of the prosecution team were involved in some decision related to his treatment, maybe arguably that would be discoverable. But I think that really what you're asking for, aren't you, is you're asking for personnel records, Mr. Bradl, aren't you? You're saying so, that. Yeah.
I think he's their primary witness. He works for the police department. He's engaging in certain conduct that looks like it's misconduct to us from the information that we have. And we don't have the entire bit of information, but they do. And
Mr. Gubitose, again, I'm trying to just cut to the chase here. Do you have, is any member of the prosecution team, as you know it's defined, in possession, custody, or control of any of this information? Or is it your position that it's in some IAD file or a personnel file? Or both?
If it is true, and the first I heard of this was when I received this yesterday morning, we don't have it. I think your analysis is correct. It's a personnel issue. If he wants to file a Rule 17 motion attaching an affidavit from a person who has firsthand knowledge of what is going on here, then I'd facilitate it.
So Mr. Bradl, so what I'm trying to articulate, it's been a long day and a long week, is that if you believe that there's some document or information that's in the prosecution team's, as that term is defined, and as we use it for discovery purposes, then that's something that I can do something about. But at least from my reading of what you're alleging here, these are things that would be found in personnel files or perhaps other documents held by the North Andover Police Department. Again, if there's some computer system that keeps track of these things, but these things wouldn't be in. You've been around long enough.
Well, let me give you a scenario, Judge.
Sure.
Let's say he screws up. He's taking prescription drugs and he doesn't show up for his shift. I would assume that would generate a flurry of emails. Sorry, I screwed up. I won't do it again. Or don't worry, Noonan. You're all set. We need you strong for the Fitzsimmons trial.
Those emails would not be in the possession, custody, and control of the Commonwealth, as that term is defined.
They'd be in the custody of Noonan. It's a police email about a police witness. No, it's not good enough for the government to say, oh, we don't have that, Judge. They have a duty, and they have a turbocharged duty under the new Rule 14 to go out and look and go out and inquire and say, what do you have on this? Bradl's saying that this guy is on drugs, doesn't show up for his shifts, doesn't get in trouble, has a collective bargaining waiver where he can go to work details when he's out on leave, none of which is in the regulations. Where's this coming from?
How can the district attorney's office possibly be in possession of that, as it's understood by the rule? Possibly be in possession of any of that information. Mr. Gubitose's represented that, I assume that his office, the prosecution team, I'm sorry, not the office, the prosecution team is not in that, does not possess that. And, to use your analysis, that would mean that everything that officer, because there's a police officer, Smith, that's involved in some arrest, that everything that officer does in other cases related to his work at the police department is somehow discoverable. It may be discoverable, but the mechanism would be Rule 17. So I'm not, to the extent that you're requesting, to the extent that the motion, not even.
Someone's phone is going off again in the courtroom. Thank you, Karen DePasquale. I'm so happy your mother's feeling better.
To the extent that the motion as it relates to Officer Noonan and these promises, inducements or rewards needs to be denied because these aren't promises, inducements, or rewards in the discoverable sense under Rule 14.
I'll file a Rule 17.
Okay, so we'll do that. And then as for, I'm not sure that you need a particular ruling on, well, let me ask you, on the first part of the motion, could I allow it? I don't even know, what's your position, Mr. Gubitose?
As far as,
to the extent
well,
that,
no, I mean, the request, I'm looking at page 7 of number 53.
yeah, let me address something that Mr. Bradl raised. To the extent that there's some motion for me to name a special prosecutor, I'm not aware of any authority that I would have to do that. There's something called separation of powers. So,
What about conflict of interest? I mean, if the court has a conflict of interest before it, I think the court can say, here are the facts. I find that you have a conflict of interest. You need to either, set up some sort of a Chinese wall prosecution system or appoint a special prosecutor. And, I think that's a legal determination. Ultimately, it's a legal determination.
I'm not aware of any statutory or common law or even constitution-based provision that would grant me the authority to order the Commonwealth to prosecute or to investigate something or not investigate something. It's classic separation of powers. So, what the issues that are before me are, again, compliance with Rule 14, the defendant's due process rights, and just getting out in front of something that may trigger a trial motion.
Could I take one more crack at it?
Sure.
Thank you. I know you have one day. Judge, I have in mind when I read, SJC decisions. Let's say a defense lawyer has a conflict of interest in his trial representing someone. I recall, in my aging brain that, the SJC said he had a conflict of interest relative to the defendant, new trial order. So the courts do say, lawyers have conflicts of interest and it has legal ramifications. And I don't see how that could be any different where the Commonwealth has a conflict. The court should be able to order it.
It's the remedy that I'm raising the issue. Okay, it's not the issue of conflict of interest weighing in on that. It's that you're asking me to fashion a remedy that I don't have the authority to do.
Maybe the court could say a non-conflicted person. You need to put a non-conflicted person in this room.
I can't. I know of no authority that allows me to meddle into what the district attorney. I can barely do my own job. You want me to do the DA's job too?
I appreciate you hearing me out.
So it sounds as though the Commonwealth is going to comply with some of these requests as early as today. They've made the disclosure on Mr. Aylaian, and as for you said you were going to look into the Detective Furman body camera and footage and whatever else is out there.
Yes.
It's in the Commonwealth's best interest to timely comply because they want to get the trial as quickly and as surely as Ms. Fitzsimmons. All right, so let's.
Have you heard on one issue?
Sure.
And this is an issue that I brought up the sidebar, issue here, that whether Rule 14 has been complied with or not, I'm asking that the court order a disclosure of any expert witness that the defense intends to call or may call I think I'm entitled to it. I've been 3 weeks away from trial. That's the only thing I think that will derail us here. And I don't think it is a big ask.
Mr. Bradl?
So Judge, I was just going to pull up the rule, but I think that the legislature in passing the rules of criminal procedure set it up this way so that the Commonwealth has an incentive to give the defense discovery. They don't get the candy until they give us theirs. That's the rule. It's not, I don't think it's really something that, they can't have their cake and eat it too. Give us all of our discovery. It's a good incentive for the government to provide everything. This is routine in every case. I think of the Karen Reed case in Norfolk County, Judge. The government didn't comply with Rule 14 until
Don't we all? Everything is now compared to the Karen Reed case. Listen.
This is routine in every case. I think of the Karen Reed case in Norfolk County, Judge. The government didn't comply with Rule 14 until the day before trial. And Judge Cannoni held the line on their discovery compliance was not due until the government complied. It's just the rule. I don't think it's really something that should be messed with, honestly. It's there for a reason. The government needs to give the defense, who has a right to remain silent, who has a right to evaluate and do something or do nothing on the case, and we have a right to look at the evidence and then decide what we're going to do.
All right, so I think if I'm reading between the lines, Mr. Bradl, your position is that you have no notice requirements under the rule right now because the Commonwealth hasn't fully complied with the rule in the way of.
Correct.
And what I can tell you, Mr. Gubitose, is that I don't think too highly of any attempts by trial, by ambush, by either side, and I'm not going to let it happen. So if the position, again, both sides are going to comply with the letter of the rules, and so the answer is I'm not going to order it, but I'm also going to be conscious of making sure that the spirit behind the rules, which is again no trial by ambush, doesn't happen to either side. So we can't. In other words, I can't fortune tell what's going to happen about. All sides are going to do their best to get this case to trial on March 23. But it won't be at the expense of the defendant's due process rights or violations of rules. It's just that simple. All right. All right. So that leaves the motion for medical records,
And that is agreed to or not objected?
No objection. Agreed either way.
The only thing is I didn't attach an order, so
Right.
I told Clerk Queen that I just sent one Monday.
all right. So, and if you folks worked out the way that this is going to be handled in the sense of they're going to be summoned into the clerk's office
Yes.
and impounded.
I can't remember the last time I ever had a procedural objection to medical records, Judge. They get produced, I'm not going to object.
Yeah, they should be not available to the public, available to the council.
Oh, well, sorry, yes.
That's
Yes, I appreciate that, yes,
No,
thank you.
okay. So all right, so this is the easiest thing I've done today. You say I can allow this without objection.
If I could put a little asterisk on it, Judge, could the defense have eyes on it first, just to make sure there's no,
I can't,
and then if there was something objectionable in terms of discovery, not admissibility, but discovery, I would immediately bring it to the courts and council.
so you're not even gonna make this thing easy?
I'm sorry. I'm sorry.
Mr. Gubitose,
And I'll come right up. As soon as they're here, I'll come right up and have a look.
so, and then what happens? So if there's something are you saying that there may be something in there that you don't want the Commonwealth?
You can look in camera and make a rule.
Mr. Gubitose, help me here.
No, the medical records. I mean, we're not asking for psychological records or anything. They're emergency room records.
I'm sure they're fine, but I'm just trying to be careful.
Well, if you're sure they're fine, then let's just handle them the standard way. Okay, and let me ask you this, I'm going to order that to the extent that copies are made, that they're not disseminated, all right, and that they're not used, that you don't file them, they'll be impounded, and that will give you a chance, Mr. Bradl, that you don't have to rush to race to Lawrence, because that's a race you're going to lose.
I appreciate it.
They're in the building. And then this way, again, there's not going to be any cat out of the bag, so to speak. It's an issue of whether they're going to be able to be used and or disseminated.
Thank you.
And that won't be the case. All right, so I'll take care of that. And all right, so that leaves, let's talk about deadlines, and then let's talk about this bail issue. So on the deadlines, so here, Mr. Bradl, is it your position that I can't order deadlines on trial motions because the Commonwealth hasn't complied?
No, Your Honor.
So do you folks want to keep the March 9 date?
I think I'm March 12th, Your Honor.
March 12th date. You want to keep that?
Yes,
So
please.
what I'd like to do is have things filed so I can look at them ahead of time, and also so that they can be served at the same time and the other side can file any written oppositions. So let's say, how about with the end of business on the 9th work?
Yes, thank you.
And then this will give you folks a couple, you'll have time to oppose also, and then we'll hear those on the 12th. And so we're talking trial motions. I'd like to get any proposed jury voir dire questions, whether they would be part of the questionnaire or part of the actual voir dire. To the extent that you have anything that's unusual or not, that would be terrific. What else? What else would be helpful is whether you, I think I've mentioned this before, whether there's anything that should or should not be in a media spectator type of order, to the extent that we folks think that we need that as well. That would be helpful. What else? Let me just take a look at my list here. And witness lists. So, frankly, I'd like to get your witness lists soon because again, if there's some conflict that we have to flesh out. So, Mr. Bradl, you need a minute or?
No,
What I'd like to do is get a list of prospective witnesses and or folks that should be mentioned somehow during voir dire. Let's say next week, I don't know, by the 4th. All right, and again, these are, can you do that? You look like,
Yes.
Mr. Gubitose, you need more time?
We can just do the 5th, I hate to be here.
Is that all right, Mr. Bradl?
Yes, sir.
All right, and just make it over-inclusive, okay? Again, the idea here is twofold. One is to for me to make sure that that I don't have any conflicts, which is not typically the case, but also so that we have something to be able to tell our prospective jurors about the image. All right, it doesn't commit anyone from calling or not calling someone. All right, so we'll do that. Mr. Roy, we got that. So yeah, let's do, I don't need a statement of an agreed upon statement of the case because you folks will never agree on it, and it's just going to be for my purposes of what I tell the jury venere, which is going to be some plain vanilla.
Well, I mean, frankly, maybe appearances don't show, but Attorney Bradl and I get along really well.
You do it, Your Honor.
So we'll give it a shot.
No, again, as I told you folks at Cyber, I know both of you professionally, and I was surprised that that wasn't the case, and you corrected me, so I'm happy to hear that. All right, did I miss anything on the deadlines, Mr. Williams, from either of them?
It's on the 12th. Is that a 2 o'clock call?
9 o'clock? 9:30. Again, with the idea of doing as much as we can on that day to get this thing lined up for trial. So it's going to be important that you folks flag if you have if there's a trial motion where you think that there should be a voir dire of some witness or something, flag that in the motion. Because again, I'm going to need to, and I'm not suggesting you need to show up on the 12th with witnesses, because we'll have to have another day to do that. But these are things I'm going to need to know. What else? All right, and then so that leaves us with the purple elephant in the living room, and that is the bail issue. And so
There's a few things, Judge, that the Commonwealth may not have too much of an issue with, that's just really hindering me, and I don't think they're really the central issues that the Commonwealth's concerned about. So could I take a crack at it? And just...
but here's the thing too, is I also, without knowing the history here, I don't want to be stepping on another judge's toes in the sense of, I have no idea what, because traditionally, not even traditionally, as a matter of law, I've always understood it that judges don't, to the extent that unless there's a bail review or a judge is retired, a judge wouldn't typically have the authority to touch another judge's 58A orders.
That's why I'd like to.
But also, from a practical standpoint, it would obviate the need for some. Well, you know what? Let me hear you, and then I would likely take it under advisement or something.
So there's a few terms that are very difficult for trial prep in the short calendar we have. This 48 hours notice business, having.
Can I admit this point? Is there somewhere that the pretrial conditions are written down? Because I didn't see anything in the file. Is there probation over there, Officer Noonan? Do you have something that's that? Do you mind showing counsel before you give it to me?
Kelsey has to give probation 48 hours notice to see her lawyer, and that's very difficult when you're trying to prep for trial.
Can you show it to Mr. Gubitose, too, to just make sure that we're on the same page?
He didn't learn the case because he's been on trial for 5 weeks on John Kerry, and he was just assigned this case. So that's the reason, Viper. Only so many hours in the day.
All right, go ahead, Mr.
Thank you, Ron. So, Judge, we have about 3 weeks before trial, and I really need to start to prepare with Ms. Fitzsimmons at the office. And the 58 provisions are just very difficult, and I don't think they're really necessary in the sense of.
Tell me what you want.
So what I want to do is I want to be able to call up Ms. Fitzsimmons, and I want to say, get in your car and drive to Boston and sit with me at my office for 3 hours on like a day's notice or a few hours notice. And, she's.
The notice now is what? You said 2 hours?
48 hours notice. It's just, I'm a bit of a moving target these days, and it's just, it's something that it's just immensely difficult to coordinate. I almost said ADA Coakley. Attorney Coakley and me and Ms. Fitzsimmons and my paralegal and her mom. Remember, her mom has to chauffeur her around. And she's the
you're saying remember, I don't, that's I do. So
it's one of these custodial things where her mom has assumed custody of her. And to leave the house on this 48-hour notice, Ms. Fitzsimmons, and I don't know why.
How many hours do you want? How many hours of notice?
I want it, but should it even be noticed, Judge? She's on house arrest, she's got a bracelet, she's got.
There has to be notice, and the reason why is because, is she on a GPS, right?
She's on a GPS, Your Honor.
The alarm will go off without.
So that's what I'm asking. So I'm just going to give you what I'm asking at first.
Can you sit somewhere I can see? Sorry. Do you mind if you sit there? Or you want to come up to the?
That's fine, sure. So I just want to be able to have a normal prep with Ms. Fitzsimmons in the sense of
2 hours?
Sure, absolutely, perfectly.
So Mr. Gubitose, what do you say?
I defer to probation. I agree. I have no problem with changing the 48 hours, but I would defer to probation because it is a legitimate concern for them.
Yeah, yeah. Well, that's why I wanted you up in the front row here. So how much time would you need to make it meaningful? And would they have to, are you supervising?
I'm not supervising the case.
Supervisor.
It's Heather Johnson out of Salem, Missouri.
I don't think I know that. Heather Johnson?
Yes. The reason we would have to know, like you said, how much, or when she's going to go up. Because we have to open up a window.
Right.
So to open up a window, we can't do it on a Sunday or Saturday. It has to be during the week when we're working. So we're able to put in the release.
Okay, so
maybe
just the mechanics.
So mechanic wise, is why don't we just give her a window, let her go out from like 7 in the morning till 7 p.m.
Well, that would be.
I want to point out too that even Brian Walsh, who has been convicted of dismembering his wife and disposing of her remains, and her remains have never been found. Even Brian Walsh, who was also on an ankle monitor, had certain times of day where he was just allowed to leave his house without telling probation. He could go pick up his kids from school. He could drop them off at school. He could go visit his mother. He could go grocery shopping. Brian Walsh had a lot of freedom with that ankle monitor on, considering what he was accused of doing, chopping up his wife and disposing of her remains. Her body's never been found. Kelsey is charged with, her only count is assault with a deadly weapon. Okay?
7 p.m.
Well, that would be opening up a window with no parameters would be something I wouldn't feel comfortable changing over the Commonwealth's objection without knowing. Again, I guess there's certain things that I'm happy that I'm willing to do to accommodate some changes where the Commonwealth isn't objecting too strenuously, where there's some uncertainty about my authority to do so. So let's see what we can agree on, and then I
just like to get a little bit of freedom to be able to sort of.
Oh, sorry, my correction. You're right. He was out on, when he had the ankle monitor on, that was for his federal charges of stealing the fake artwork. You're right. And then he was held without bail for the murder. You're right. That example doesn't really work here. Except, I don't know, selling $80,000 worth of fake Andy Warhol paintings to a collector. That's a federal charge, but is it a more serious charge than what Kelsey's being charged with? All right. Withdrawn.
A little bit more on the fly, if you will, kind of get in and prep with me and come to my office and work on the case.
Right. But there needs to be, so I can tell you.
Yeah. Use the Karen Reed example. Karen Reed was charged with second-degree murder. She didn't even have an ankle monitor at all. No conditions. No alcohol monitor. No alcohol monitoring. She had to pay money. Kelsey's ROR, but yeah, good point. Not even an ankle monitor on her. Thank you, Allie.
This is that I'm not going to open up a window, just some standing window. I just wouldn't do it for any defendant. So to the extent that at the end, I see that as a significant change that, again, you would need to determine whether Judge McCarthy would need to hear that or not. So why don't we try to be practical and work on what.
So if the court's willing to do a 2-hour window, we would appreciate it.
Would that work if it's during the week and during working hours?
Usually during working hours, they could reach somebody in probation to be able to put a window. So I don't know exactly why they put the 48-hour window. It's not my.
No, I understand.
I wasn't there. But usually I see 24 hours on some cases, but I don't know specifically for this case. I don't know why 48 hours.
So here's what we're going to do is we're going to try to narrow it down, and then I'm going to step off the bench because I haven't even read your motion. And I want to just take a look at 50A, and then we'll come back and I'll change what I think I can change. And All right, so,
Thank you, Your Honor. And just before you go, if I could just.
no, I'm not going anywhere yet. I want to hear all of
Yeah, okay.
what you're seeking to change.
So we'd appreciate if you could do a 2-hour notice requirement. You know, her mother chauffeuring her around is an immense hardship. She works full time, and, you know, it's not fair to have her drive to, there's one page. There was some custodial determination that.
But custodial determination and an order as to where she should live is different than carting somebody around. Is there like a no drive issue or whatever here?
So this is one of those things that, you know, it may have been said from the bench that Miss Page, her mom, needs to be with her when she goes out, and that she can't drive herself. There were a lot of pronouncements from the bench, and, you know, we don't want to.
Can somebody in the front row help me here? Is there some order that's prohibiting this?
Front row tells you everything you need to know.
Honestly, I don't remember that. But having said that, I was up here when I got this, so I don't have my file with me, or.
I don't see, Officer Nunez, I don't see any. Yeah, I said, I do see provide proof of appointments to probation with 48 hours notice. But I'm not seeing any, you know, occasionally you'll see a judge will order that the defendant can't drive, operate a motor vehicle or anything like that, but I'm not seeing anything
So,
here.
you know, I'm just trying to comply with the plethora of things that were handed down from that bench, Judge. And what happened was Ms. Page was brought up and put under oath, and the court made all sorts of pronouncements, verbal pronouncements, that she couldn't leave, that Ms. Page had to be with her at all times. She had to drive her places, or at least be with her when she went to places. And, you know, we don't want to.
It's not in the written order.
Right, I understand. And, you know, I'm trying to do the right thing. And, you know, that was what was said by the court. Well, and so we don't want to run afoul of anything that court said, you know, but there were an incredible amount of things that were put out.
If it's not in the written order, you're not running afoul.
Okay, and if the court's going to have that for me, and then I very much appreciate it. And if she can do that, that's what I need, is that she needs to be.
The Commonwealth isn't claiming that there's any conditions that have been imposed that are not in the written order, correct? As far as you know, it's.
Yeah, I don't think so.
So I would appreciate the court protecting me on this by making a ruling that the written order is the order, and we will comply with the order, certainly. And, you know, it's almost like an integration clause in a contract, you know. All these verbal pronouncements ought not to be enforceable.
I have no idea about verbal orders. I can tell you is that my ruling is you comply with the letter and spirit of the written orders.
Thank you.
That's all.
That's all we need. Thank you.
Right, so what else do you want me to change?
Ms. Fitzsimmons.
I'm sorry, consider changing.
I appreciate it. Ms. Fitzsimmons is working on her own residence versus living with her family, which is, you know, difficult for an adult at this point to live with a family.
So when you say working on, you're not asking that now.
She has a place and she has a lease. She's not going to sign it unless the court says it's okay. But she wants to have her own place in Newburyport.
That's a big ask. That's a big ask right now. And I'm not saying that let me say this, is that on the 12th, I think which is the next day of the week, I'm going to try to get some clarity on as to what the law is, that to the extent of what I'm able to change. So, but I'm not saying that I wouldn't, I'm just saying that it strikes me as something that is a significant material and enough change that I just need to.
I understand. So what we're looking for today, 2 hours notice, she can drive herself, she can leave the house, come to Boston, work with us at the office, drive home, you know, without fear, and she has a lot of fear based on how this case is unfolded, about running afoul of anything. She got sent back to jail when she couldn't blow into a SCRAM machine, when her rib was literally blown up, and she got sent back to jail for it. So she's pretty terrorized, and I don't use that word too hyperbolically. And so she's very scared to do this stuff.
Okay. So, I understand, but again, my view is that she complies with the written order, the spirit and the letter of the written order. Actually, really just a letter of the written order because it's an order. And she will not have any, run into any trouble with me as far as I'm concerned.
All right, appreciate it.
But let me, anything else in the bill, because I want to step off for 5 minutes and just take a quick look at the 58A. But right now, basically, what's before me is a request to just change the notice requirements. And you want that changed on other appointments as well, like the doctor's appointments?
Yes, please, Your Honor.
I mean, it does seem like those types of appointments would be set up more, but does the Commonwealth object if I change all appointments to mental health?
Well, it's my understanding that she's on a schedule where she meets people as far as that goes. I was assuming that probation and the defendant were on the same page about when she was leaving for these appointments.
She has some Zoom mental health appointments that she takes, but I don't.
Yeah, but let's just leave the timing on the mental health, on the medical and mental health appointments the same way it is, and then I'll have a better answer on the 12th on whether it's something that I would entertain. All right.
And then the last thing, Judge, is this order that she can't go, essentially, that she can't prosecute a custody case in probate court, family court.
What do you mean by that? Show me what you're talking about.
There's an order, and this may be one of these verbal pronouncements, but there was an order that she may not, I believe there was this was written somewhere, that she has to stay away from her child, and that, in essence, any probate or family court custody order does not supersede that or can't affect that. So the Superior Court is basically telling the family court, we don't care what you do over there. We don't care that you're the experts in this. You can't go near your child, regardless of what the probate court says. So Ms. Fitzsimmons is in this custody case over there that's
I think I can truncate this, and that is that there is a provision that does say have no contact, direct or indirect, with victim, witnesses, and own child, OWN. And that must be what you're referring to.
Yes, and there was an even more explicit pronouncement somewhere of it.
So
regardless of probate court.
Again, I need to think about whether this is something that I would entertain or not. But does the Commonwealth, would the Commonwealth object if I were to entertain changing that to be, comply with? She's already ordered to comply with all court orders, which includes probate court orders. We are not the experts in. The probate court is the experts in custody, visitation. They handle all that. So I wouldn't want to get dragged into that, but I don't know. I wasn't there for the hearing.
Yes, that's the problem, that you're in a position that you know nothing about the hearing, nothing about the evidence that the judge looked at, heard, and considered when she did that issue. So,
all right. So the Commonwealth objects. So then, perhaps that would be something that could be. Again, reevaluated on the 12th. Anything else? Then let me just step off for a couple minutes and just take a look at the data.
I just have trouble with the idea of the Commonwealth even having any standing to object to, where Ms. Fitzsimmons can go, which court she can go to address child custody issues when the child's not a witness. The child had nothing to do with this.
The Commonwealth is not saying that. I don't understand. At least I don't understand the Commonwealth to be saying that. The Commonwealth is my reading this is the Commonwealth is saying very simply that there's a condition of her release under a criminal statute. And this is what a judge ordered, and they're objecting to it on the grounds, and I don't want to speak for Mr. Gubitose, on the grounds that this, like all of the orders, was part of a framework for the release. And again, this may or may not be something that I would entertain. All right, so anything else before I step off?
Just the last thing, Judge, and I know and I respect and I appreciate that Your Honor wants to defer to the other judges when there's other rulings. Obviously very common in our system. But in this case, I can't fight against the ghost. The court made a very strange ruling where I filed a motion to recuse her for bias and violations of the rules of judicial conduct. Perhaps wisely, Judge Ricciuti intercepted that motion, which we all know was supposed to go to that trial judge.
Right.
And in 24-hour turnaround, he said, it's moot. She's going to be in another session or to that effect. And so she's either out of the case or in the case, Judge. And, you know, if I can't have my client's liberty hindered. I want you to feel free to make rulings on this case. And she's either in or she's out. And I think Judge Ricciuti assigned you the case. I don't know what happened, but, you know, here you are. And I'm glad for that. But I feel like you need to be free to make the rulings.
Okay, and that very well may be the case. I don't know. And again, I'm starting with the assumption that Rule 58A does not allow me to make those changes. And let me take a look at the statute. It is a bigger issue, because I don't think that I've been that there's been an order assigning me this case. I was assigned the trial, but it makes sense for me to take everything. So just give me a couple minutes.
Thank you.
We'll reconvene in 5 minutes.
All right.
Okay, well, we're behind, so we have some time to move ahead. And Bradl is going full force on this today, as well he should. Listen, either McCarthy Neyman's off the case or she's not off the case. Within 24 hours of us moving for her to be recused, Judge Ricciuti, who's the head mofo judge in charge over there, apparently, took her off the case. And this is after the 5-minute break.
On the 12th, when we're back in.
Okay. Today's February 27th, 2026.
On the 12th, when we're back in, because my hope is between now and then I'll get the formal appointment and then I'll feel more comfortable about having the authority to change it, to make the changes. And then, but I will say this though, my thinking is on the issue of the order related to no contact or stay away from the child is I would need to see, because I don't know what I don't know. What is the probate court involvement with the child? So you don't need to answer that. What I'm saying is that if I can be provided some documentation so I know what it is.
The parties stipulated in the probate and family court, tell me if I'm wrong, they stipulated that she would have no contact with the baby. But just because there's a stipulation doesn't mean that she can't go back into probate and family court to try and have that changed, right? Thank you, Mass Dad. I love it when we agree on stuff.
In other words, some documentation that shows me that the probate court is addressing, contact, visitation, custody, whatever is related to it, because there was a provision, if I remember correctly, in the 209A, where the probate court ordered, I believe, the that to at least temporarily custody go to Mr. Aylaian. So if I can get some sense, because that's all I know of what the status is, some documents, then I'd have more information to be able to change that. But it makes sense if that's the case.
Well, with the caveat is you had declared earlier you know very little about this case. So I'm assuming the exhibits from the 58A are in the file. And if they're not, so Your Honor can review. And
let me be clear. When I say know little, I know all that's in the file, okay. And that includes I've read the police reports. I've read the Dr. Zeisel's report. I didn't see grand jury minutes, but I've read. I've seen
there's another report in there talking about her longstanding issues and things like that. So
let me say this: I will not make any.
Another affidavit in there with her longstanding issues of alcohol use. Yeah, those were all from a different proceeding in a different court. An affidavit with 4 people's handwriting, Judge. That's what they got on her. And Judge McCarthy Neyman used all of that in her rulings, and she may have had some ex parte communications with other people and obtained other information. That was alleged in the motion to recuse. And then she was very swiftly removed from the case without an opportunity for that motion to recuse being heard. And she was in custody when they made that stipulation, as I recall. So there's been a change in circumstance. And again, the family and probate court is the proper venue, in my opinion, to determine whether or not she can see her child. The fact that Judge McCarthy Neyman went above and beyond and put that in her order of bail conditions may be outside her scope and jurisdiction, but she kind of did whatever she wanted. We saw it.
Changes without knowing, having all the evidence before me. That goes without saying.
So I can just tell you just what's coming, Judge, in terms of documentation. So, and I hope this gives the court a comfort level, is that there's the restraining order that he got in family court is still there. So
it's not a matter of comfort level. Right. It's a matter.
Nothing would happen if the court says, we're vacating this, we're leaving this to probate court. What you'd be leaving it to is an existing restraining order that hasn't had the benefit of a 2-party hearing since going back all the way to July or June 30th.
Right.
So,
but that's something that Ms. Fitzsimmons can do something about. I mean, all right.
It's tricky. It's tricky.
Okay,
it's a bit of a catch-22 because you got the family court judge looking at this saying, well, I can't do anything because the Superior Court's telling me I can't do anything. And Ms. Fitzsimmons has another counsel for the custody case, and she's sort of waiting in the wings to see if we can have Your Honor address this, no probate court order.
Okay.
And once that happens, I think then we can address all these things in family court.
So what I would ask from the Commonwealth, actually both sides, is that at some point you take a look at the file and make sure that I do have that everything that I need to know about the 58A and the terms is in the file. And again, I've already talked about the court-related documents, and whatever else it is that you've raised on the conditions, the change in the conditions. Again, we'll address on the 12th, and that assumes that Chief Ricciuti assigns me, which I assume will happen. And that's where we'll leave it. So let me, Officer, go ahead, Mr. Gubitose.
No, I think we're wrapping up. I just need to put one thing on the record.
Yeah, I'm not wrapping up yet, but we're getting close. I promised the staff that we're wrapping up and getting close. Officer Nunez, so you have this order, or Mr. Ricciuti, I just gave Mr. Ruane a promotion. I called him Ricciuti. How can I change this? Can I make a change on this? On this copy?
So they're kicking the can 2 more weeks. She's going to have to wait 2 more weeks for maybe an order that allows her to go back into probate and family court to try and see her baby now that she's out of custody. She needs to wait another 2 weeks to find out if she doesn't have to give 48 hours notice to go see her lawyer to prep for trial. The trial is coming up on, what did we say, March 23rd? She's going to have to wait another 2 weeks until March 12th for the judge to get up to speed on her bail conditions and whether or not she can drive, whether or not she can sign a lease to go live by herself and get outside of her parents' custody. But it's not over yet, so hold on.
We could do some new ones. If you want to change it on that, we could actually make new ones.
Don't make a new one. Let me just, here, I'm going to change it on here, and if you could make some.
Camera person focusing in on Kelsey's feet, where she is shaking her feet. She is probably very upset right now. And it sounds like the man who's there from probation is saying, "Why we could just amend this order right now." And the judge is like, "Yeah, I don't want to do that right now." She's got to be exhausted. She's got to be just thwarted at every turn. How much time did she spend unnecessarily in Chicopee Women's Prison?
We could do some new ones. If you want to change it on that, we could actually make new ones.
Don't make a new one. Let me just, here, I'm going to change it on here, and if you can make some kind of a docket entry that, where is the follow treatment, provide proof of appointments to probation, allowed out for medical court attorney visits. You know what, there's a provision here. I'm just going to change the attorney visits with 2 hours notice. And remember, Mr. Bradl, we're talking about during the week, so I know you work weekends.
I do.
Right? And like any trial attorney. And so if there's going to be some meeting on the weekends, she's got to
respect the 2 hour notice.
No, it's more. She's got to set that up during the week while probation is around.
Oh, okay. I see.
She can't just wake up Saturday morning.
I was hoping to give probation like a schedule of meetings for like a week and a half.
I thought you couldn't do that. I thought the whole idea here.
If I had 2 hour notice, I could be more flexible. You can't do 48 hours. 2 hours I can manage. And I appreciate you not doing this thing.
Well, they're going to change
There's
that.
a lot of provisions in here that the court needs to look at and grasp and get up to speed on.
So I'm going to change that. So I just wrote in that. What I would do is let's make a copy of that and docket it. And then you can give copies to each side so they'll have it. That's the only thing that I've changed. And you folks have your deadlines, which Mr. going out. Maybe I'll do some procedural order so that there's what else?
I just wanted to put on the record, defense counsel had listed just really 3 things that he was missing. Detective Furman's report, he actually has that. The body camera of Sergeant Strong at the hospital, he actually has that. I'm going to help him find it in the discovery. So the only thing outstanding is the OneDrive link, which we'll do Monday, and my email to him memorializing what we just talked about. After that, I'm filing my final certificate of compliance.
Thank you, Your Honor. That's appreciated.
And let's all work cooperatively. It sounds like you folks have. And let's get this thing to trial. All right. Okay. Yep. Oh yeah. So. Anything else? Otherwise, we will.
Your Honor, just the conditions. There's also GPS conditions that has this.
Oh, you're right. You're right. Give me the other order, please.
Again, the judge has been on a murder trial for 5 weeks, and he was just recently assigned this case. And everyone in Massachusetts says he's an amazingly fair and upstanding judge. There's only so many hours in the day, and at least there's a small win
So
today.
I wrote attorney visits for 2 hours, advance notice to probation. So that actually, this is probably a better mechanism for doing what we but I've changed both orders so that, that is it. Okay, so we'll see you back 9:30 on the 12th.
Thank you.
Thank you. Thank you.
All right. What's that, Teresa?
That was a long conference.
Yes, sir. Yes, sir, you right here? Oh, okay, down probation. Yeah, we'll go down.
Probably should look at the exhibits. That's okay. No. Well, anyway, he wants to make sure that this is fine.
Yeah, today, Satan. I'm just going to mute it, and that was it, I guess. That was it. Thank you to Boston. Was that Boston 10? For streaming that so we could watch it, but we're not done yet. We're not done yet because I wanted to show you guys the papers that Bradl filed this morning and what exactly he was looking for today, because he spoke about it a little bit. The judge seems hesitant to undermine any other judge's filing with regard to the 58A dangerousness order. And he's been on a trial for 5 weeks. He's been on the John Kerry trial for 5 weeks. We've done some shows on that. John Kerry is on trial right now for murder, a 1986 murder of a girl named Claire Gravel, who was at Major McLeish's pub in Salem and was found dead. The defense is that there were 2 cops who were never investigated for Claire Gravel's murder. And that trial has been ongoing for 5 weeks. Apparently, it's going to the jury on Monday. Nobody's reporting on it. I don't think anybody has been covering it. And we can't cover it either because there's no Zoom. There's no camera feed in there. The fact that nobody's covering this is wild to me because it could be something like the Edric Foss trial that we just covered in Georgia, where a person, the only evidence against them is touch DNA on the very devastating murder of a young, I think she was in college at the time, on her tank top. And this man is on trial for murder. And this one goes back to 86. Edric Foss' case was 25 years ago. It was from 2001. Gubitose, the district attorney, ADA in Essex, came right out and said, we're not charging Justin. For those of you who have not seen the video of the break-in, hold on, because I'm going to show it to you now, in case you haven't seen it. And then at 6 p.m., we're going to come back and we're going to do all the Karen Reed new filings. The O'Keefe's really don't want Karen Reed to be able to get her phone back. For those of you who have not had the opportunity to see the video of the break-in, I'm going to show that to you now. This was 3 days after Kelsey was shot. She was clinging to life at Mass General Hospital. She was airlifted from the scene after the shooting. And this is when Gubitose says he didn't break in. He called North Andover PD and they told him he could go over there and get whatever he wanted. Wow, just wow. Here's the video in case you haven't seen it. Pay special attention to the door on the right side of your screen because you're going to see Justin it for the money. Justin Aylaian, as the ADA called him, breaking the door down. And if you're a firefighter, you know, you're taught how to break doors down, right? Looks like he tried to use his key at first, but he couldn't. If you haven't seen it, come to your screen if you can do so safely. Here you go. Bam! Oh, his sunglasses flew off of his head. There's Justin for the money. Seemingly no care in the world, with 3 of his buddies trailing in behind him. And then what you'll see next is, timestamp on that portion of the video is 9:35:31 a.m. These are new cameras that Kelsey's dad had set up the day before. Justin clearly didn't know that the cameras were there, because we've seen other video from this angle on the day of Kelsey's being served with the orders. Yeah, didn't he say he just pushed the door open? Yeah, That's 9:35. Other guy gets in. And then they go straight down to the basement. Okay? Because the camera on the right side of your screen now is the basement camera. And the time on that camera is 9:35:54. So within 20 seconds of entering, Justin and his buds are now in the basement. They're now in the basement. Gubitose said he just went there to get some of his stuff. (9:36:20 a.m.) And that's it. But they're not going to charge her. I'm not going to charge him. So now this judge has ordered, Judge Karp, that she only needs to give 2 hours notice when she wants to go see her attorney, but it can only be during the week. Those conditions have been changed. Why did he need his 3 friends for this? That's a great question. It's insane. This whole thing is insane. But they're coming back on March 12th. The judge is going to familiarize himself with the file. He's going to review the statute to see if he's allowed to amend Judge McCarthy's Neyman's order. And that's all the video that I have for you today. They claim, I'm sure there's more video, but that's what came out yesterday. Attached to the motion that we went over yesterday. So go back if you didn't see that video. I mean, the live stream that we did yesterday, go back and watch it. Here's the filing from this morning that we did not have a chance to review before this hearing, but this was just filed by Tim Bradl and Martha Coakley this morning. This is defendant's renewed motion for bail determination under section 57 and or 87 of chapter 276. I haven't even read this yet. Now comes Kelsey Fitzsimmons by and through undersigned counsel and hereby requests respectfully that the court admit her to bail under section 57 or under agreed terms pursuant to section 87 of the bail framework. As grounds, Ms. Fitzsimmons respectfully states that her original bail determination was generated under highly questionable circumstances, including the use by the Commonwealth of an expunged criminal matter, and other circumstances resulting in 58A bail release conditions fairly described as medieval, imposed only after 103 days of incarceration. The allegations in document 51, the motion to recuse Judge Kathleen McCarthy Neyman, and request for evidentiary hearing previously filed and incorporated herein by reference. As a result of the bail conditions, Ms. Fitzsimmons cannot drive on her own, must have her mother, who works full-time, drive her everywhere as her custodian, must give 48 hours notice for legal and medical appointments, and must be on 24/7 lockdown otherwise. She wears a GPS bracelet and blows into an alcohol device. There is a superior court order that she cannot independently seek custody or visitation of her child in probate and family court, although her baby, 4 months old at the time of the incident, has nothing to do with the charge or her getting shot. The ongoing custody case in that court is stalled by the orders of the prior judge in this court. Judge Karp did say that nowhere in the order did it say that she couldn't drive, so he was okay with her driving. These terms are beyond extraordinary for this case. The sentencing guidelines call for probation for this one assault with a deadly weapon charge. There are no grounds for these onerous pretrial restrictions on her liberty. Ms. Fitzsimmons asked for a fair bail determination, allowing her to live in her own home, drive herself around at liberty from 7 a.m. from 11 to 11 p.m., put exclusion zones in place 1 square mile from the alleged victim's home, and work accepting highways, home and work accepting highways, exclusion zone 1 square mile from father's residence in Stowe, Massachusetts, accepting highways, and either abandon the alcohol restrictions, which are completely unwarranted, or allow her to submit to random urines. She will assent to these terms at present under Section 87 of the bail statute, so she may properly prepare for trial. He did say that she wanted to sign a lease on a place in, Newburyport. You guys said that was a really nice place. And the judge will not rule on that, or did not rule on that today. That is all reserved for March 12th, as well as the alcohol monitoring restrictions. Kelsey Fitzsimmons, footnote 1. Ms. Fitzsimmons is a lifelong North Shore resident with indelible roots in the community from her upbringing, friends, family, job, and education. She went through the Methuen public schools from kindergarten to senior year in high school. When she graduated high school, she continued her education at Fisher College in Boston, majoring in criminal justice. She chose criminal justice with the goal of becoming a police officer, a career that was a lifelong calling for her. While studying criminal justice, she became the president of the Criminal Justice Club, where she was responsible for hosting many events on campus that pertained to important topics related to criminal justice, such as domestic violence, suicide awareness, fire safety, etc. She was inducted into the Criminal Justice Honor Society. Ms. Fitzsimmons held a position at 2 different jobs that pertain to her major. I'm going to zoom through this. You can read it at your leisure if you like. We've read all of this before. This is pulled from other motions. She went to law school. She became a corrections officer. She then applied to North Andover PD and became a North Andover police officer. She's dedicated her life to 2 things, her law enforcement career and her baby. She's never harmed or threatened to harm her baby. These are all allegations that Justin made ex parte in family and probate court. Like countless new mothers, she had suffered from a transient bout of postpartum depression. She had been found by an expert clinician to be not dangerous and deserving of reunification immediately with her child. See the report of Dr. Paul Zeisel filed as Exhibit 7. As of the date of this incident, which we know, she was cleared to return to work as a police officer. She was scheduled to return to work on July 4th. Again, a lot of this is repetitive of what we read in every other motion in the many, many, many live streams that I've done on this case. So if you're not familiar, you can screenshot this stuff and read it later. I need to leave soon to get ready for the 6 o'clock stream on Karen Reed. And it is already 4:38. The argument is she is also entitled to the presumption of personal recognizance. He says the court retains inherent authority to revisit conditions of release when justice so requires, particularly where the prior ruling was tainted by legal error or reliance on inadmissible information. At the original dangerousness hearing, an incident from North Carolina was referenced and relied upon in support of a finding that Ms. Fitzsimmons posed a danger and was presently an alcohol abuser. Those records have been expunged. They had been expunged. I think she was something like 21 years old at the time. Expungement is not symbolic. It is a legislative declaration that the incident is to be treated as though it did not occur for purposes of collateral consequences and legal prejudice. Courts in Massachusetts have repeatedly recognized that expunged matters may not be used to enhance punishment, determine credibility, or otherwise prejudice a defendant. Reliance on expunged records in a 58A proceeding undermines the integrity of the dangerousness determination. Further, and then it goes on to say some other things, and they shouldn't have McCarthy Neyman should not have relied on that in making her determination. Furthermore, Ms. Fitzsimmons has already demonstrated she can comply with court orders. The impositions of house arrest and the continued stigma of a dangerousness finding are excessive, punitive, and unsupported by the statutory standard. So here is what Bradl is suggesting that the court does with the terms of release. Continued GPS monitoring with exclusion zones of Stowe, Massachusetts and North Andover, Massachusetts, allowing Ms. Fitzsimmons to leave her home to meet with her legal team on her own at will without 48 hours notice. Well, they changed that to 2 hours notice. Live in her own residence. Judge said, come back on March 12th and we'll talk about it then. Maintain mental health counseling sessions with documentation of attendance to probation. Apparently she's on Zoom, so that doesn't change. Maintain stay away orders. And 5, the foregoing proposals will maintain a proper balance between the court's need to supervise the defendant with the defendant's presumption of innocence, liberty, interest, health concerns, demonstrated history of nonviolence, and lack of criminal record. The judge is going to do some more research. They're going to come back on March 12th. And apparently the trial date, March 23rd, is going to happen, according to Judge Karp. I put a lot of these super chats up during the stream, so thank you again to M. Monge, who said, I'm confused about the video. Has it been played in court? Are they doing it today? No, I just played it for you now. We played it yesterday during our stream yesterday, so thanks for your 5. 0 chance her husband, well, he's not her husband. It's her ex-fiance. Thank you, Anthony. She's effed. He's effed. Well, they outright said they're not going to press charges against him, even though they have a conflict, sent it to Middlesex. Middlesex sent it back, said we have a conflict. And we saw that right before our very eyes. The watcher wanted to know if anyone confirmed that he didn't plant any evidence. Thank you, Ellen, who said all the way from Denmark that Justin thought there was no surveillance because law enforcement removed it and didn't know that Kelsey's dad installed a new one. It was a motion long ago that Bradl was asked for the hard drive surveillance. Yeah, they seized the hard drive surveillance and they've got it. The Commonwealth does. Thanks on top for all of your super chats today. Kelsey got her second wind. Thank you. How dare you from Canada. Thank you, Gigi, for all your super chats today. She thinks the prosecutor should have eaten his eggs this morning instead of leaving them on his face. Maureen said earlier, I started this. I'm late today, catching up regarding Claire Gravel. Opening arguments are Monday. No, actually, the trial has been going on for weeks. She says her brother is friends with my husband. Dad is having a hard time. It's sad. I'm really sorry about that, but the case is going to the jury on Monday. So the trial's over. Thank you, Maureen. I just wanted to catch you up on that. Skybell, thanks for gifting. B Crumbs, thanks for gifting 5. Nicole wanted to know if he has permission to steal a laptop, a passport, $5,000 and dismantle security. No, he didn't. Thanks, Nicole. Bethany, thank you so much. I'm sorry your kids didn't get their walk after school because you wanted to watch the live, but we're happy you're here. Thanks for your 5. And Ellen said, why destroy video surveillance if you're doing nothing wrong? Great point. Thanks, Ellen. You can see it all the way from Denmark. The world is watching. And you guys are loud. Kelly says he went with 3 equally large younger men and he was frightened for his life from her dad. What's his reason for hacking and theft? I'm so done with the Commonwealth BS. Thanks, Kelly. She can see it from across the pond. Optipop, she should take it to the feds. Plenty of federal crimes alleged, wire fraud and identity theft at least. Thank you for your 10. Dina says, where are the feds? Love living here in Massachusetts. It's scary. Thank you, Dina, for always being around and being boots on the ground. And for your 10. Joe Mar gifted 5 memberships. You're the greatest. Norman said, Melanie Stowe is in Middlesex County. Why can't Middlesex file charges against Justin? That's where the bank fraud took place. Well, they gave the case to Middlesex. According to the DA, you might have missed that part of the hearing, Norman. Go back and listen to it. Middlesex sent it back saying we have a conflict. And even though they had a conflict, Gubitose looked at it again and said, yeah, we're not going to press charges. Nick from Sweden says, how is Justin's action different from swatting? Both are lying to cops to get a person hurt. Yeah, he lied to the cops too. He did that too. That was pointed out. Nobody seems to care. Anthony says, Justin is just another Chris Melton. State protected. Thank you, Mel's Travel Buddy, for being with me for 7 months. The judge wants to do his research before he makes his decision. I can't really fault him for that. He got thrown into this case. He got parachuted into this case. Sandy says, I'm frustrated. Judge is unaware of status quo. Well, he's been on trial for 5 weeks, like I said. Jojo says, with all the drama on X injustice is getting left behind, I'm grateful you're not in the pool. Refreshing. We need to free Kelsey. Yeah, I don't know what goes on over there because people try and drag me into that drama all the time. I don't engage over there. So I've been so busy covering other cases in which defendants really need the coverage and really need justice that I don't have time for the nonsense. So thank you for, I'm not involved. Elizabeth says, and she can't go anywhere because Justin has her passport. I don't know if she got it back or not. I don't know if he returned it when he allegedly returned the laptop. I don't know. Capable Human says, isn't calling them to say the alarm is going off. An effing clue, it's not his house. Geez, this is lunacy. Yeah, because the code was changed and everything else. It's wild. Isn't it? Don't you think? Thank you, Betsy, for your 10. She says XOXO. Thank you, Sarah, who says, why is this prosecutor allowed to stand on a soapbox and interrupt Bradl every time he speaks? Thank you, Sarah. And Gigi, I think you bought me 5 matcha lattes. Thank you very much. You are the best. The best. Back to my notes for a moment for a brief recap for those of you who've been here the whole time or those of you who are just chiming in. Just tuning in, actually. Apparently, there was an officer who went to visit Kelsey in the hospital from the MSP who may have body-worn camera that the defense said they didn't have. But in the end, the ADA Gubitose said, you actually you do have it. We learned that. That was new information. Yeah, I mean, it was alleged that he took gift cards and money and transferred them. All of that is in yesterday's stream. It's a very long and involved stream, and we read all the papers on that yesterday. Go back and watch it if you haven't. Tim Bradl said in the beginning, this court proceeding has been a circus. I'm really glad you're here, Judge. Judge wants a joint witness list. Questions for voir dire for the jury. Apparently the Commonwealth took the surveillance system. There's going to be a ballistic expert for the Commonwealth. And in fact, the ADA called Noonan the shooter at one point. There's a Detective Furman in this case. We've learned Detective Furman is the one who, yeah, the air quotes were crazy. Furman was the one who went to visit her in the hospital, and he is with North Andover PD, we learned in the end. They spoke about the promises, rewards, and inducements motion that we covered yesterday, and all of that relates to Justin and Noonan. It's been decided that for the Noonan portion of that, Bradl has to file a Rule 17 motion to get that information. However, the Commonwealth is going to be required to turn over any information of promises, rewards, or inducements that were given to Justin Aylaian, because that's what the ADA called him, Justin Aylaian. The judge did bring up that the motion did not include affidavits from Kelsey Fitzsimmons and Steve Fitzsimmons, which I noticed yesterday when I was reading the motion. I thought that was a little bit odd too. And the ADA, in fact, said, well, you know, it's not really a big whoop because Justin's not really a percipient witness in the case. Again, with the air quotes, even though Justin was in the house at the time the shooting of Kelsey Fitzsimmons occurred. When it was brought up that Justin broke into Kelsey's house that he had no right to break into and disabled the alarm system, tore out the surveillance system, tore the modem out of the wall, stole the laptop, the passport, and cash and other things. The ADA's response was, well, Justin called the North Andover Police Department the day before he broke into the house, and they told him that he could go into the house. Justin asked for a police escort, said Gubitose, but they wouldn't give him one. So he went there the next day, and the alarm went off. And so I think he called the police again and said, I'm worried. I'm really worried that Kelsey's family, they're very, what was the word that he used? I didn't write it down. Vengeance. They want vengeance on me. So I'm really worried. Then Gubitose said, but I haven't talked to him about that. It is what it is. It is what it is. It is what it is. And again, Bradl said, it's a big problem, Your Honor, because Justin, Aylaian, also lied to the police when he called them and told them that he had every right to go into that house. So there's another charge that he should catch. But again, the DA's office in Essex County is not going to prosecute Justin because they just don't want to. There's this talk about Noonan receiving special treatment and that he may have a drug issue. That was brought up. That was in the motion yesterday. He took a Flexeril. He didn't show up for work. Police department sent some people over to do a wellness check on him. And he said, oh, sorry, I overslept. And then he was put on some critical incident leave. The judge was opining that he might not have any authority to order the Commonwealth to name a special prosecutor. Commonwealth wants everything. They already filed their certificate of compliance. And they're not supposed to until they've done everything, until they've turned everything over. And the defense's time should not begin to run to turn over their discovery until their certificate of compliance is actually accurate and real, that they've turned over everything. The witness list will be due by the 5th of March. Trial motions are due by the 9th of March. It's already February 27th. The next conference will be held on March 12th at 9:30 in the morning. And then the trial is set to begin on March 23rd. There was also some talk about a media and spectator order. I don't know where he was actually going with that. And so I guess that will remain to be seen. However, a small win for Kelsey is that she only needs to give 2 hours notice, but only during the week, to go visit her attorney's office to prepare for trial. Is there a post-court? Somebody said there's a post-court presser. Hold, please, for 1 second. One moment. Hold, please. Somebody said that Jessica Machado posted a video of a presser, but I don't see that. I don't see a video of it. Did anybody else put it up? Oh, please. Let me see if Michael Bryant was there for that part. And it looks like they used Law Girls Not Attorneys feed for their live, so we were on Boston 10. Anybody know? I just can't find it quickly. Here's what's going to happen right now. I'm going to send you over to the 6 p.m. stream of mine for, hang tight one second, for the Karen Reed stuff. And so you will be teleported over there. Oh, please. And then we will look at the thoughts, questions, comments, concerns. Is Jessica on YouTube? Is she on YouTube with it? Oh, look, I'll take a look in 1 second. Jess is live on YouTube. Okay, I'm gonna check right now. I have to just change one thing on I gotta open up the chat on the other stream. It's the whole thing. All right, got it. Got it. Hold, please. Shout out to Jessica. Go on over. Give her a like and a sub. Doing the Lord's work. Boots on the ground. Needs a little boost. Hold, please. All right, here's the post-court presser, courtesy of Jessica Machado.
Attorney Bradl did all the work. And also take the lead here. And also. Yeah, so Attorney Bradl did all the work for you. Says representing Kelsey.
The audio is not great.
I think today was.
The audio is not great. I can't hear it.
Well, we wanted the family courts are doing their job. So we expect that to be addressed soon, and we're optimistic, and we're very happy to have Judge Karp on the case. I think we're going to get a fair shake, and it's going to address it very soon. And that's, Kelsey's #1 priority.
Yeah, this is Jess. I can't understand what they're saying, but you guys can go find that on your own. I'm gonna go prep for the 6 o'clock. I'm gonna as soon as this is a drama-free zone. It's just not gonna be tolerated. If you come in here and you trash other creators or whatever, no matter whether I like them or not, I'm just not gonna tolerate it. So just don't do it. Just be classier than that. You can do it. I promise you. All right. Buckle your seatbelts. We're going to go to the 6 p.m. stream. A lot of craziness happening over there. The O'Keefes have filed a motion for a temporary restraining order. They're trying to get the judge, Judge Doolin, to not release their phone, Karen Reed's phones back to her. And she's filed a response. And then there's a reply. And there's all kinds of things. Go take a break. Come back. Hydrate. Stay cool. Stay kind. Stay classy. And above all, stay safe because it's a jungle out there. Share the stream out. Please hype it too if you can when the stream is over. I will transport you over to the 6 p.m. so you have an hour to go hydrate and have a little dinner and then come on back because it's never over when you think it's over. There's always more. But wait, there's more. Safe travels, cupcakes. I'll see you real soon. Peace.